the documents that were circulated, along with all the paperwork for all parties who are party to the application, both the applicant and the interested parties who have submitted representations. I'm not going to seek to go through them, as they are guidance notes for the committee, for the members of the public and the applicant to be aware of, just in terms of the outlying legal nature of the proceedings, and how the hearing is going to be undertaken. If I may, I'll just progress to the procedure that we're going to follow, which is at agenda item 6. The procedure that the paperwork has been included within the paperwork is that the chair will open the meeting, introduce themselves and the committees, and will be calling upon parties to identify themselves and identify any witnesses as and when it comes to be sort of their turn to make their representations. Secondly, that the chair of the subcommittee will call upon the clerk of the committee, and I'll be acting partially in that role today. Excuse me.
Matt, can I just, sorry to interrupt, but you're having trouble hearing, are you?
Okay, I apologize. Is that better? Okay, I can speak. I'm just conscious that I also can't look at you. I'll speak up. There should be some speakers in the back of the room, which I'm hoping IT will be able to work for us in a moment, if they're not already, but I will speak up. I do apologise. So I'll be acting partially in the role of the clerk of the committee to explain the procedure. So unless the chair directs otherwise at any point, each party will have a maximum of an hour in which to give any information and call any witnesses to their case. In all cases, everyone will have the same maximum length of time. You don't have to use it, but you will have the same length of time as everyone else. The chair of committee would normally call upon the interested parties or the responsible authorities in terms of who's going to talk in which order. I'm going to do that today, given the number of people we have present. Hopefully that is okay for everyone. The process when we call an interested party is we're going to start with the people who've made representations. They will have an opportunity to make their comments. The applicant may question, if they wish, that person. The members of the subcommittee will have the opportunity to question that person. Any other people, sorry, that representative or representee will have the ability to call a witness in support of their representation. And the applicant will have the ability, if they wish, to question that witness. The members of the subcommittee will then have an opportunity to question that witness. Those steps will be followed through for each and every party that wishes to speak. And then moving on from that, the applicant will be given their opportunity to make their case in relation to the application and state their representations. There'll then be the opportunity for parties to question the applicant at that stage, and members to question the applicant at that stage in relation to the matters. After that, there will be the ability for all speakers and the applicant to close and offer a closing statement, at which time the members of the committee and the legal advisor will retire to determine their decision. And then, obviously, depending on time, we will come back into this meeting room or inform you as to how the decision is going to be given to you and at what stage. So if there's nothing else, Councillor, I would just ask that one slight change to the procedure is that we would just read out a section of the report, give a summary of the reasons that we're here today, one of the officers, and then we move on to the first representative. Thank you, Chair.
Thank you, Matt. Okay, moving along to item 7, which is the main business for this hearing this morning. I'll pass you back over to Matt Burton. Hopefully you can all hear what I'm saying. No problems with that. Good. And he will explain the report going forward. Thank you.
Run through the report. Thank you. The purpose of this report is to inform the subcommittee of an application for a new premises licence which has received relevant representations. So sorry, you want me to go slow? Betley Court Farm currently holds 2 other premises licenses, one which allows for concerts to be held over the second weekend of August each year. The premises licence and plan for this is attached as Appendix A, with the licence number 9323. The second premises licence permits licensable activities in relation to Betley Bonfire, Betley Show, Betley Gun and Game, a specified young farmer event in 2015, and 5 other events. This second premises licence and plan are attached as Appendix B, with the licence number 12337. The current application and plans under reference number 21250 are attached as Appendix C. They show the details of the new application, which is intended to replace the licence 12337, allow for more flexibility for events in the outside area, and to allow the sale of alcohol in the tea room and associated bed and breakfast accommodation. Clarification of the application details regarding the different activities was provided by the applicant following distribution of the report, and this was sent to all parties on Friday, the 5th of August 2022. The application was received on the 21st of June 2022. The site notices were checked on the 28th of June, and the notice was placed in the local paper on the 28th of June also. The last date for representations was the 19th of July. In the course of the statutory consultation period, 36 relevant representations were either objecting or requesting additional measures were received, 7 of which were subsequently withdrawn. The remaining 29 representations are attached as appendices D1 to D29. A further 11 representations supporting the application were received, and these are attached as appendices E1 to E11. All those representations received by email on the 15th of July were directed to further information on the council website in relation to making representations, and some took advantage of this to make additional comments or relate to the licensing objectives more directly. 2 took advantage of this opportunity, while 2 others stated that they were satisfied with offering support only. Since the report was circulated, Mr. Peter Panay, Appendix D11, and Mr. Simon Goodall, Appendix D18, have withdrawn their representations. Mr. Mike Reeves, Appendix D16, and Mr. and Mrs. Hemmings, Appendix D12, have stated that they will not be in attendance, but have made the following statements. Mr. Michael Reeves: I have no objections now to almost everything that is being sought by the Speed family, other than if a member of the Speed family would publicly announce that they will guarantee they will not hold hugely large scale pop concerts such as the ones we have had to endure in the past, then I would willingly withdraw all objections. I know a number of other objectors who would wish for the same. And Mr. and Mrs. Hemmings have said, our comments are purely objective and are based on our experience of poor traffic management and parking at large events. If the problems of traffic management and parking were better addressed, we can only wish the Speed family every success. There were 11 comments of support and 1 comment of objection, which did not reference any of the licensing objectives or matters that could be attributed to them, but showed the residents' general opinion on the matter. 1 representation was received late and has not been taken into account in any of the above figures. We were also in receipt of an objection from Environmental Health, which is attached as Appendix F, who have since withdrawn the objection subject to the agreed conditions, which were sent out to all parties on Friday, the 5th of August, being incorporated into the operating schedule of the licence if it is granted. The police have agreed conditions that they would like adding to the operating schedule of the licence if granted, which are attached as Appendix G. Acknowledgements were also received from the Planning Authority and Staffordshire Fire Service, in which they advised that they had no objection to the application. A check on the council records shows 5 complaints. The first complaint dates from the 21st of June 2013 and inquires as to whether the premises has permission for an event being held later that day. It was confirmed that the event had been organised through a temporary event notice. The other 4 complaints relate to the Young Farmers Ball and Betley concerts, which were held on the 8th of August to the 14th. The 8th of August and the 14th to the 16th of August 2015. The complaints relate to noise from the events, including sound checks. Noise monitoring took place as part of both events, and it was found that there were no breaches prior to 11 o'clock that evening at the Young Farmers Ball. However, whilst the music was turned down at that time, it was still audible at the boundary of the premises until the end of the event at midnight. It was also found that the noise levels were above recommended levels in the daytime at the concert event on several occasions. Recommendations were made by Environmental Health in regard to mitigating these issues, and no further complaints are registered on our system since. A map of the location of Betley Court Farm is attached as Appendix H. Officer's recommendation, in accordance with the Licensing Act 2003 and the licensing policy and guidance, would be for members to consider the application, taking into account the relevant representations and in particular the conditions agreed with the responsible authorities. The subcommittee, where it considers that action under its statutory powers is appropriate, may take any of the following steps for the promotion of the 4 licensing objectives. The steps available to the subcommittee are listed below. The relevant options are to refuse the grant of the application, to grant the application with amended conditions, to grant the application but restrict the licensable activities, to grant the application with restricted times, to grant the application as it has been proposed, or it could also be granted with a combination of the restrictions that were mentioned. For this purpose, the conditions of the licence are modified or amended if any of them are altered or omitted, or any new conditions are added. The subcommittee are asked to note that they may not modify the conditions or take any other steps merely because they consider it is desirable to do so. Any action taken must be appropriate in order to promote the licensing objectives. Thank you, Chair.
Thank you, Mal. Right, I'm now going to ask Matt if he could go see has a list of in order to call on you guys to come down and have your say. So I'll pass back over to Matthew. Cheers.
Thank you, Chair. First person we'd like to call to speak is Darren Walters from the Environmental Health Department.
Good morning, committee, and good morning, Chair. I appear on behalf of the Environmental Health Department. My name is Darren Walters. The Environmental Health Department is a responsible authority under the Licensing Act 2003, and we consider all the licensing objectives under the Act, those being prevention of public nuisance, public safety, prevention of crime and disorder, and protection of children. Okay. We lodged an objection to the application on the basis of public nuisance originally to enable us to have discussions with the applicants and to clarify their intentions. I'm pleased to say that now that the licence has been clarified as detailed in the agenda, that we've come to a position where we have agreed conditions with the applicants. There's just 2 minor amendments to those conditions that I'd like to inform the committee about. The first one is the prior written notification of planned events involving 500 or more persons and a noise management plan. We wish to ensure that the noise management plan has approval prior to the event going ahead. So it's not just a case of submitting a plan and then going ahead. So this will mean that the noise management plan will cover all noise sources for events involving 500 or more people. And so that'll be from performers, generators, and also amplified sounds. So not just music, but also film performances, PA announcements, that sort of thing. Okay. We've proposed a noise level in there which the applicant has agreed to. That noise level is derived from national guidance for outdoor concerts. We feel that that's appropriate, and it's a condition that also applies to the Betley concerts. So it's fairly similar in scope and what it's achieving there. So the idea is that up until 11 p.m. for the events that they're planning to have, any amplified sound that is reproduced from the speaker systems would be at a conversation level at people's dwellings. And then the post 11 o'clock, then what we're looking to achieve there is that basically the sound would be inaudible. It would be down to background noise levels that exist at any other time. And we also control the bass elements there as well. So that should mean that the amplified sound isn't obtrusive or causing a public nuisance to anybody, both during the events and also during the more sensitive sleep hours, 11 o'clock onwards. We're also asking for the community to be informed about noise tests, the noise arrangements, and also a complaints number to be given to the community in advance of the event. So obviously anybody who has issues with the noise is able to make a complaint to the site, and then for the site then to arrange for appropriate monitoring to take place. As part of the normal procedures, then those complaints would be documented, and then we could go back to those and discuss those complaints post-event with a view to seeing what further controls we may need to discuss as part of the noise management plan for future events. So hopefully a case of continual improvements should issues arise. But I'm fairly confident that what we've proposed there should mean that public nuisance isn't caused to any residents within the village. Okay, so the two amendments that we're looking for is the noise management plan to be provided and approved by the head of regulatory services prior to any event. And for the noise sensitive premises, condition number 4, towards the end, for that to be changed to dwelling, so it makes it very clear as to where the noise level conditions apply. So that will be to any dwelling within the village. So for example, the closest dwelling to the furthest dwelling away in the village, the idea would be that if they achieve it at the closest dwelling, automatically it's achieved further out. Simple law of physics there. Okay. So with those 2 additions, the applicants and Environmental Health have agreed those conditions with those 2 amendments, and we commend those to the committee for inclusion on the licence today. Thank you.
Okay, thank you, Darren. Councillor Brown, do you have any questions to ask? No. Councillor Panther?
No questions.
Okay, no questions from me either.
I'll just say, sorry, just do the applicants have any questions for Mr. Walters?
No questions, but really just to confirm that the conditions together with the 2 minor amendments mentioned by Mr. Walters are agreed. So thank you.
Okay. Any further questions? No? Okay. Thank you, Mr.
Thank you, committee.
Okay, please can we call Councillor Richard Head for the Parish Council?
Good morning, Chair. Good morning, committee. My name's Richard Head, and I'm a member of the Betley Parish Council. In the absence of the chairman, I'm speaking on behalf of the Parish Council. I'm the only representative of the parish council. Any other councillors attending would be speaking in a private capacity. The parish council is not a statutory consultee, but is permitted to comment as an interested party.
Mr. Heck, sorry for the interruption. Could you talk into the microphone, please? With the members of the public who are having trouble to hear you. Thank you.
Is that better? Is that better? Any better there? I don't know. I mean, I'm speaking as close as I can to the mic.
Having an issue with the microphones. Could anybody hear me? Yes. Right. That was a lot better.
Apologies. As I say, the parish council is not a statutory consultee, but is permitted to comment as an interested party, a body representing persons living in that vicinity. In view of concerns expressed about the licence application by a number of residents of the parish, the council called an extraordinary meeting on Friday, the 15th of July, to hear the views of residents and to enable a response to be formulated. The meeting was attended by 31 individuals. Although the parish council was aware of 4 objections at that time and an anonymous leaflet being delivered in certain areas of the village suggesting residents object to this application, nobody at the meeting spoke against the application and one person had no view or abstained. The parish council asked the licensing committee to consider all the submissions carefully and base their decision on the facts. In making this request, the parish council is not taking a view on whether submissions either for or against the proposal are accurate, but is simply making a general observation. The parish council passed the following resolution. The parish council requests the licensing committee to note the points made by those in favour of the application and those against the application, insofar as they relate to the council's licensing policy, specifically public safety, protection of children from harm, prevention of crime and disorder, and prevention of public nuisance, and to develop appropriate licensing conditions to enable the licence to meet the needs of the business whilst addressing the concerns expressed by those objecting. The reason for this resolution was to ask the licensing committee to develop conditions to protect the community and environment whilst meeting the needs of the business. In reaching a decision, the parish council based its view on the views expressed by the community, whether in favour or against the application, the views of the meeting, and the 4 objections seen. The parish council noted, but could not take the content of the anonymous leaflet into account, given the leaflet was anonymous and its status unknown. Whilst not making a value judgment, it is considered that a number of the concerns raised by objectors can, if the licence is approved, be addressed by the licensing conditions to meet the requirements of the borough's environmental health department, which, by definition, should carry significant weight and ensure the protection of the local environment. Similarly, the views of the police will carry significant weight, and their requirements, which will be aimed at protecting our community from harm or damage, should form part of any licensing conditions. I'm told the applicant is working with the police on such matters. Finally, as far as other events, meaning events excluding Betley Show, Betley Bonfire, and the licensing of the tea room are concerned, the parish council is of the view that Common Lane, should only be used as a means of access to and from the site in an emergency. This should be a condition of the licence. As far as the site itself is concerned, an appropriate noise management plan needs to be developed and implemented. This should be a condition of the licence. In conclusion, the tea room, as far as the tea room is concerned, the parish council has not been made aware of any concerns in respect to the 4 criteria mentioned in the resolution. Numbers, circa 40, in the tea room are restricted by the number of, tables, and so the sale of alcohol will not increase numbers and is not expected to have any adverse effect on matters protected by the 4 criteria. Other events. Leaving aside significant larger events such as concerts held previously, as far as other events such as weddings, lunches, public events and private parties are concerned, the parish council has not been made aware of any concerns in respect to the 4 criteria, and such events appear to have been well managed to date. That is the statement I've been asked by the parish council to read out.
Okay, thank you, Mr. Head. Councillor Brown, any questions for Mr. Head?
Mr. Head, you mentioned that Common Lane should only be used for emergencies. Could you tell us your reasons for that, please?
I believe that in the past, it has been used by some people unofficially to exit from events such as the bonfire. It was certainly, as I understand it, it was never an official exit, but people are obviously aware that there was a gate onto Common Lane, and we feel that that should only ever be used in emergencies.
Thank you, Councillor.
Councillor Panter.
Yeah, thank you, Chair. My only concern with Common Lane is the site. I'm not familiar with the road. How big and wide is it? You know, can emergency vehicles access it all right if necessary?
Common Lane. Common Lane was it?
Yes, sorry.
It's a narrow road. As far as I understand it, emergency vehicles would be able to get down there. But it is we've got to be aware it's a narrow, unadopted road.
Do the applicants have any questions they wish to ask?
Excuse me, just one. Sorry, it's a kind of form of question stroke comment, if I may. The applicants don't have any issue at all with the with your desire for Common Lane only to be used as a means of access and egress in an emergency. I'm just not sure now if I can pass it over to the committee as to whether that should be a condition on the license. But in terms of working with the applicants, they're agreeable to the principle. Okay.
Are there any further questions? No. Okay, thank you for your time, Mr. Head.
Thank you, Chair. Would it be possible for me to be excused from proceedings? I've got a hospital appointment.
Yeah, that's fine.
Thank you.
Okay, Matt, if you could like to ask the next speaker to come.
Thank you, Chair. Could we have Michael and Sylvia Covell, please?
Morning. My name is Michael Covell. I live in Court Walk, Betley, which is very close to Betley Court Farm and to the land surrounding Betley Court Farm. myself and my wife have lodged an objection to this application. Basically on one or two major conditions. We're concerned about the fact that the owners of Bentley Court Farm wish to have applied to hold as many events as they wish throughout the year, at any time throughout the year, at any day throughout the year, up until from 11 o'clock in the morning until 11 o'clock at night, and then on 10 occasions per year, up until 1 o'clock in the morning. We have no concerns at all about applying for premises license for the tea room, for holiday lets, or for the surrounding area. Our concern is primarily with holding pop concerts or concerts for young people that will cause noise and disturbance and a nuisance to residents who, particularly those residents who live close to the farm. And I, in common with quite a number of residents, as you've seen from the applications, first 31 and now 29, wish to object to that because we have suffered in the past from noise of concerts being held in the natural amphitheatre that is very close to our house. And while I applaud the owners of Bentley Court Farm for their ingenuity insofar as that they've turned their farm or the farm buildings, many of the farm buildings, into other uses, to holiday lets and to businesses and so on. But we object to this particular application because they will hold pop concerts. I have already met the owners of Bentley Court Farm in my house, and they've explained to me that the events that they have held in the recent past, while very popular and were well attended by villagers, did not enable them to generate the sort of returns they wanted to make. And as a result, we all know that the only way they're going to be able to do that is to hold some form of pop concerts, which are going to bring young people in who are going to make a lot of noise, as they have done in the past. And even with the noise conditions that they've had in the past, we were still bothered by the noise, both during the day and mainly at weekends it was held, both during the day and in the evenings. And we couldn't sit out in our gardens because of that. So we don't have any objections to Bentley Show or Bentley Bonfire or these long-established traditional events in the village. In fact, myself and my wife have both actively helped out and supported these events. But we do object to the idea that Bentley Court Farm will start to hold pop concerts again. And we're very concerned about the noise implications and the nuisance on many other residents of Bentley. And I'm speaking on behalf of some residents in my area who unfortunately couldn't attend today as well. 29 people have put their heads above the parapet and have written letters saying that they object to this application. I don't think they actually object to parts of the application, neither as we don't, but we do object to the idea that the owners of Bentley Court Farm will hold pop concerts and we will be bothered by noise and disturbance, and it will create a nuisance. I think I have written a very detailed letter of objection, which I hope you will take into consideration and not allow unknown number of events to be held. There's a farm very close to Betley, which is outside of Betley, called Budley Farm, and that is restricted to holding, I think it's 8 particular events per year, weddings a year they generally hold, and it must finish at 11 o'clock at night. All of that seems to me perfectly reasonable, and that's well outside of the village. Betley Court Farm is right in the centre of the village and surrounded by residential dwellings. And I think you in your position have a responsibility to make sure that while we want the owners of Betley Court Farm to be successful, that should not be at the expense of the lives of residents who live in the village. That's all I have to say.
Okay, thank you for that, Mr. Colville, yeah? Colville, yeah. Apologies. I'll open it up. You have any questions, Councillor Brown?
No, Mr. Corvale's covered it in detail. Thank you, Chair.
Councillor Panther?
Yes, Chair. Mr. Covell, is it the question of pop concerts in itself that you object to, or is it the noise level or the timing that of it?
All three. The timings, to go on to 11 o'clock at night is bad enough, but to ask for another 10 events to be held until 1 o'clock in the morning, and then people will leave the site and making a noise and so on. So we object to that. We object to the noise levels, because with all of the noise levels that have been put in place, when they held the last events, the first ones were terribly noisy. Gradually, because of various complaints, environmental health put in place further conditions, and that did help. They also moved the position of the stage and turned the speakers away from the village. Again, that was an improvement, and I freely admit that. But it was still very audible. Both particularly on Saturday afternoons when the announcers were there shouting to the teenagers to try and make some noise and things like this. That's what they were actually shouting to. There was no regard for the residents of Betley and the surrounding area.
Okay, I have a question for you. As a resident of Betley, how do you find the Betley bonfire? I mean, I'm not too familiar with the Betley show, which has happened over this weekend.
Yeah,
but I obviously am aware of the bonfire. How do you find that when that comes around?
well, it's a once in a year activity. They use a lot of the proceeds from the bonfire to support various organizations in Betley. So because it's a once a year activity, and it does cause a lot of disruption, traffic is horrendous, and you only have to read the press reports from the last time Betley bonfire was held, November the 4th, I think, last year. But because it's a traditional village activity that has been running for a number of years, because it does a lot of good for the village, or generates money, which is given to organizations in the village, residents are prepared to put up with it. Because but when I moved to Betley 31 years ago, I moved to a quiet residential area close to a farm in the countryside. I did not move to an entertainment centre, which is gradually what it seems to me and others, what Betley Court Farm is becoming. And it's totally unsatisfactory in a residential area.
And the Betley show?
Betley show has been running, I think, for about 156 years. And I have actively I've been a patron, my wife and I have been patrons of Betley Show for many years. I have actively supported Betley Show by going and standing on the gate and taking money and handing it to the organisers and so on.
Right, so you actually involved a lot with the Betley Show. I was asking what the noise level.
My wife and I have actively supported Betley Show, but because it's it does disrupt village life. Or if anyone's going out and coming back to their home, they can sit in a queue for traffic and things like that. But it's a once a year event, and it's been running for 150 odd years. We have no objections to Betley Show or the bonfire or Betley Dog and Gun Show and all of that. These are one-off events that are traditional, not pop concerts, which is what will happen. We actively supported the two events that were held in the last 2 years. The Songs Under the Stars and Annie Get Your Gun. And they were really nice events to attend. Yes, there was some noise created, but it wasn't to the extent that we've had in the past. And I've lived through those pop concerts in the past, as other residents here today have. And the closer you live to the actual event, to the stage, the noisier it is, obviously. And it's not just the event itself. You have all of the noise of the forklift trucks when they're assembling the equipment, the machinery, all of that constant beep, beep, beeping that goes on as they're assembling the stage and equipment. It goes on before the event itself and lasts a long time. And is really noisy and noticeable and causes a nuisance.
Okay, thank you. Any further questions from yourselves? No?
Just one point, Mr. Coyle, do you not feel that the environmental health speakers address the noise level sufficiently?
No.
In which way would you want to see an improvement?
Well, they have made improvements from when the events were held on a hill. I'm not too sure what the hill's called. Then the noise traveled much further. They then moved the events to a small natural amphitheater area and turned the speakers away and directed the speakers towards the mere. Well, that improved things for myself and other residents who live in our part of the village. But I do know that residents further down the village, depending on the wind and so on, were then more aware of the noise than we had, as we had been.
Any questions from the applicants?
It's just a few. If I may, it's clear from what you've said, Mr. Covell, that your real objection is to what you've described as pop concerts. Is that correct?
It's the noise emanating from that sort of activity, yes.
And these are the concerts that were held, well, before 2016. There haven't been any concerts.
Well, the pandemic stopped things, didn't it?
Well, in the last 2 years, yeah. But
and then prior to that, I understand that there were some problems and the pop concerts didn't generate the returns they wanted.
Yeah, but just to the core of my question, it hasn't been an issue since 2016, obviously allowing for the two pandemic years, because there
have been the odd celebration, whether it's been a wedding or an anniversary or whatever, which we've been aware of. And Jen Speed has told me about it in advance.
Yes.
There weren't too many of those, so we could hear the noise, but it wasn't a problem. I've only found it necessary, I think, to ring Jane on one particular occasion about it. The rest of the time it's basically been okay.
Okay, thank you. That is helpful because this application isn't about pop concerts. It is. Have you seen the modifications, the changes to the application? First of all,
yes, I've seen those changes.
So
I still feel that it doesn't preclude pop concerts.
Okay, well, in effect, what the application is for a limit of 10 events, which would fall in the category, of weddings, anniversaries, private party events. And they would be restricted to 10 events per annum, so not 365 days. And in addition, that if events were at a higher capacity, because as you see from the changes, the applicants are content to accept a 1,500 capacity as a maximum, that those events would take place in the lower field. So 1,500 isn't going to be a pop concert type event. It's the private events that are kind of categorized as anniversaries, weddings, etc.
For 1,500 people?
Well, it would be a maximum. Not all events, of course, weddings and anniversaries, they don't often attract that number, but there will be, there will be some.
It's clear from the numbers concerned, in my opinion, it's clear that there will be concerts of a pop music nature. I have asked the Speeds directly, please give me an assurance that that's what you're not going to do. If you tell me that you're not going to do that, then that will be fine.
Well, I won't get into a debate with you about it. Thank you, Mr. Covell. But just turning to the other elements of the application, the tea room, you don't have an issue with. The bonfire, as you said, the show, you don't have an issue with. The other element of the application is the theatre shows, and it might be film shows, which would take place in the mostly in the lower field, which is called Mere Meadow, possibly for a smaller number in the top field or the shed. But for those type of shows, which aren't categorized as pop concerts, you don't have any issue with those?
No, I don't.
Okay, thank you very much.
Further questions? No? Okay. Thank you for your time and thoughts, Mr. Colville. We'd like to invite the next speaker, please.
Yes, thank you, Chair. Can we ask Tricia G and Mr. Rankin, please?
Morning, Chair. My name is James Rankin, and I'm representing Tricia G, who's a local resident. And I wondered if I could set out my stall and explain precisely where we are with this application, because the goalpost changed last Friday, and we've had an opportunity to consider their new proposals. And the position that Tricia G takes is that the application is still objected to. Can I just identify the things that we don't object to? We don't object to the Betley show. We don't object to the bonfire, although it's a nightmare when it's taking place. We don't object to the game fair. We don't object to the licensing of the tea room. We don't object to people in the pig pen being able to have an off sale to them. That doesn't concern us. The outside of the tea room does concern us to a small extent. And if granted this license, we would ask that it be restricted for the outside area until 9 o'clock. it's as well to remember what they've got at the moment, because it's only when you analyze what they've got and then look at what they're asking for that you realize precisely how much they're asking for. So the history was this: they ran pop concerts badly in 2014. It resulted in a review of that license in 2015. And then the last pop concert they had for a large audience was in 2016. In 2015, they also applied for a second license, and that's the one that they're seeking effectively to amend with this application. That was heavily objected to by Mrs. G. And the result was this, that you granted, or the committee granted them a license. They could have their Betley show, they could have the Betley bonfire, they could have the game show, but only 5 occasions were they able to have licensable activities, and only if those licensable activities were inside a marquee. Now, that position has worked really well for the last 7 years. They put on their weddings, they put on their birthday parties, but because it's inside a marquee, the noise is contained. What they're proposing now is so far removed from those 5 occasions and the Betley shows that it's an astonishing, we would say, approach to licensing. What normally happens is you say, well, look, you granted us 5 7 years ago. Could we have 10 events per year? They're not saying that. They're saying we want 10 special events until 1 o'clock in the morning for 1,500 people. The capacity for the marquees at the moment is only 450. So you're tripling the capacity. They're saying it's not going to be in a marquee. It's going to be outside or inside. And then in addition to that, they're saying, and for the other days in the year, the 355 other days, we want to be able to put on events as well. So you go from 5 to 365. Now, that, I hope, is a message that I can drum home to the committee, that it's not just a question of 10, it's 365. And it doesn't matter whether Mr. Cavell is more concerned about the concerts or not. As far as Mrs. G is concerned, if you're putting on musicals, Annie, Get Your Gun, and the rest of it, which are outdoors and are amplified, then there is just as much concern for that as well. Now, nobody can fault the Speeds for their commercial savviness and know-how and the rest of it. And that's always to be commended. But life is a balance, particularly when it comes to licensing. And an imbalance will be created if the license is granted in favor of the Speeds in the terms that they are. Now, when I say imbalance, if licenses were granted or refused simply on the sheer weight of numbers, then this license should be refused. You have a 2/3 majority against the grant of this license. You have only 1/3 of all the objectors or all the representations that have been received that are in favor of it. Now, Mrs. G is not a naysayer. She's not saying, well, they can't have their license altogether. That, of course, is what I would urge on you. And I'd say, look, just refuse this license outright. But in the spirit of compromise, what she proposes is this. And I don't speak for all of the other residents when I make this proposal, but I put it to Mr. Cryer outside the committee room earlier this morning, that she's perfectly happy for all those other matters that I've spoken about, plus the outdoor area ceasing at 9 o'clock. And they could have an increase in the numbers of events to, and I'm going to say 9 events. I say 9 events because Budley Farm, that you heard mentioned by Mr. Cavell, is in an area not very far away. You'll know this area. It's not very far away. It's in an area which is not so densely residentially populated. They have a license, and their license restricts them to indoors, so inside a marquee, and for 9 occasions a year. So Mrs. G says this, all right, we are prepared for your numbers to increase. So the current cap is 450. We're prepared for those numbers to increase to 499. And we're prepared to countenance an application that grants 9 occasions during the year when they are able to have their weddings and anniversaries and the rest of it. And it would be subject to stringent conditions. The conditions that were put forward by the Environmental Health Officer, Mr. Walters, would appear only to apply to events where there were more than 500 people. We would want Mr. Walters' conditions to apply irrespective of the numbers of people that are attending the event. If you're holding an event and it is an event to which a number of people are coming and there's amplification that's going to take place, and it's not going to be indoors, then we would want strict conditions on it. We say that the fact that the events are existing and contained indoors is a matter of great benefit, and we would like that position to continue. Now, they can, of course, apply for temporary events notices. So the fact that they have 9 events for 499 people until 2230, which was what was proposed by Mr. Cryer in his letter of last Friday. The fact that they have those doesn't prevent them applying for additional licenses by way of temporary events. Now, what you may have seen through all the papers is some suggestion that, applying for temporary events notices is a paperwork for us. And if we have a license which allows us everything that we want, then we wouldn't have to apply for temporary events notices. They haven't been applying for their temporary events notices. If there's any suggestion from Mr. Cryer or from the Speeds that the process of applying for temporary events notices is an onerous one and ties us up in all sorts of paperwork, that's incorrect, because an analysis of the numbers of temporary events that they have been able to apply for over the last 7 years reveals this. This year, they've applied for 1. Last year, they applied for 2. The year before that, they applied for 1. And then they didn't apply for anything for 4 years previously until 2016 when they applied for 3 and 2015 when they applied for 4. They can apply for 21 temporary events notices. Now, if they're saying, oh, well, we're running out of temporary events notices or it's a lot of paperwork, you fill in a form and you do it 10 days before the event. If you're late, if it's 5 days before the event, you can still fill in the form. You pay a small fee and you get your license granted. The importance about the temporary events notice is that it allows the Environmental Health Officer to monitor each and every event. That's the advantage of it. The disadvantage in granting Mr. Cryer 365 days permission to do licensable activities, whether it's 10:30 or whether it's 10 special occasions until 1 o'clock in the morning, is that places the onus back on the residents. And you may hear Mr. Cryer say this, well, that they can always apply to review. They don't want to do that. this is one of those instances where we're not predicting what will happen. We know what will happen because it's happened before. Just by way of example, when that license was granted, the one that they seek effectively to amend back in 2015, as a special one-off, it was said, look, can we do the farmers' ball? And can we do it till 1 o'clock in the morning? And can we have 650 people? They held the farmers' ball. It did go till 1 o'clock in the morning, and it resulted in a number of complaints. So we know this. When you have a capacity of 450 and when it's inside a marquee, there isn't a problem. When you have a capacity of 650 and it's inside a marquee, you still get a problem. It's a question of the numbers and the facilities that have been put on. So it doesn't matter that it's an anniversary. It doesn't matter that it's a birthday party. It doesn't matter that it's a wedding. All of those are activities that generate sound and noise. And we say this, look, it's perfectly possible to have a wedding for 500 people. I cannot remember ever attending a wedding which had more than 300 people. They can have their wedding for 500 people. They can have their anniversary. They can have their birthday party for all those people. But that, we would suggest, provides the balance. Not an imbalance as being asked for by the speeds, not the 365-day imbalance, but the balance that was met when Budley Farm applied for their license and got 9 days. And we say, well, look, that seems eminently fair. We accept that matters can move on from 2015, but we still want it constricted and restrained. Now, I do hope that Mrs. G is not asking for the moon. She has lived in the village for many, many years and simply asks this modestly: may I continue to live in the village that I love, with the people I love, and not be disturbed on numerous occasions? It comes as no comfort to me, says Mrs. G, that I can apply to review the license. I don't want to have to do that. I don't want to have to instruct somebody to represent me when I am distressed and upset by what happens at the farm. So this is my one shot at it, says Mrs. G. Please, will you listen to what I'm saying and allow them what we would say is the correct license? Now, there are a number of ancillary matters. The letter of objection from Mrs. G you'll find in your agenda papers. I'm not asking you to turn it up, but it's at page 107 of your agenda papers. And it identifies a number of issues which we raise and which we say indicate that the application itself is deficient. See your finger twitching there? No, I'm wanting to push the button. So the letter says this, that it's hard to envisage a worse location for a place that wants to act as an events venue. Normally, the sorts of places that you encounter, that you license for events, are those that are set in deeply rural communities that have very few neighbors. If you turn to page 157, there's the map there, and I'm going to hold it up and just indicate what it is about the village that causes difficulties. So you've got the A531 running north to south. The roundabout for the motorway is up at the north of this plan. Just by way of example, because that's the only entrance in and out of the village. You can go down some side roads, but every side road will get you back to the A531. When they had the Betley bonfire, there was a 2-mile queue which went all the way back to the motorway, and it received a great deal of local press. And that's because the majority of people, when they're attending events at Betley Farm, come from the north, and they come down the A531 and then have to turn right into Betley Court, or they can turn left into car parking, which is temporarily arranged for the bonfire. In order to turn right, the traffic has to be stopped. So anybody that's coming from the south that wants to go into their village is effectively stopped from doing that. Now, there's mention also in the objection about a natural amphitheatre which is created. That's because the farm itself and the land attached to it slopes downwards. So all of these houses are higher than the farm itself. And at its highest, the residential dwellings are 100 foot above, 100 meters, 100 meters above the farm itself. And what that means is that sound that's generated, it doesn't matter whether it's a 50th birthday party or whether it's a wedding, sound that's generated moves upwards and affects all of these dwellings. Now, in addition to that, to the topography, we mention the application itself, which we've said is vague and lacks clarity. I'm not blaming Mr. Cryer for this, because it may be that the Speeds, when they made the application, made it without the benefit of legal representation. There's no magic in having legal representation, but what it means, and I know that your principal solicitor, Mrs. Pollard, is going to be listening carefully to this section in my submission, because there are various hoops that you have to go through when you make an application. The first hoop that you're asked to do is to conduct a risk assessment. And that's a duty that's imposed by the DCMS guidance. It's paragraphs 8.41 to 8.49. And it's also a duty which you identify in your statement of licensing policy. And any applicant that makes an application is duty bound not only to have regard to the DCMS guidance, but more particularly your policy. And if your policy is saying, well, we would require a risk assessment, then they've jolly well got to do it. So this is what paragraph 3.3 of your statement of licensing policy says. All applications for premises license must be accompanied by an operating schedule. This should be drawn up following a full risk assessment of the activities to be undertaken and contain the information requested in the application form, to include a floor plan, details of licensable activities proposed, the opening hours and operating arrangements. Now, when I say that the operating schedule is hopelessly ill-prepared, I do hope that you do not think that I'm overstating it. There is a requirement in the Licensing Act to provide plans which detail precisely what is intended. And if I take you to, and this is more particularly for Mrs. Pollard's node, the hearing regulations, and in particular, Regulation 23. Now, just before I do that, can I indicate, because it's in the application itself, this is the plan of the premises. There's a plan of the tea room, that's absolutely fine. But what they've done insofar as the upper field is concerned and the lower field is concerned, is they've just stuck a red line around it. This is what they're required to do by law. And it's in Regulation 23 of the Licensing Act 2003, Premises Licenses Regulations 2005. An application for a premises license under Section 16, which this is, shall be accompanied by a plan of the premises to which the application relates and which shall comply with the following paragraphs of this regulation. So you've got three mandatory urgings there. The plan shall show the extent of the boundary, they've done that, the location of points of access to and egress from the premises. That's not shown on the plan. If different from subparagraph 3b, the location of escape routes from the premises, they're not shown. In the case where the premises is to be used for more than one licensable activity, the area within the premises used for each activity, not shown. Fixed structures, including furniture or similar objects temporarily in a fixed location, but not furniture, which may impact on the ability of individuals on the premises to use exits or escape routes without impediment, not shown. In the case where the premises includes a stage or raised area, which if they're going to be doing plays, I imagine that's what they're going to be doing, the location and height of each stage or area relative to the floor. We haven't a clue, nor it appears do they. In the case where the premises includes any room or rooms containing public conveniences, the location of the room or rooms, not shown. All we've got is this. You've got Mr. Cryer saying, it'll be really nice. We're going to be doing weddings and we're going to be doing parties and we're going to be staging plays. Some of them are going to be 1,500 capacity and there are going to be 10 of those. Others, well, they're not going to be 1,500 capacity. They're going to be 499 capacity. But I'm afraid I can't tell you what's going to be happening. I can't tell you where the stage is going to be. I can't tell you where the loos are. I can't tell you where people will be escaping from in an emergency. We've had chat about Common Lane, but that's it. None of the requirements of the hearings regulations have been complied with. Now, of course, I'm tempted to say, but look, just throw the whole thing out. But that means that we just have to come back again. A solution to all of this is to say, well, we agree with the residents. We do not think that the plans that the applicants have at the moment, commendable as they are, we do not think that those plans have sufficient clarity to enable us to grant a license for 365 days in the year. What we're going to do instead is we're going to do a Budley. We're going to grant for 9, and then you come back at a later date and you tell us exactly what you've done. You tell us how well these events have been run. You show us that you've had difficulties applying for temporary events notices. You show us that there are very few residents that object because they're all perfectly happy with your operation. And then we will increase the numbers. But we're not going to do it now. We're not going to give you 365 days. We're certainly not going to give you 10 days for 1,500 people until 1 o'clock in the morning. Now, does that sound as if a compromise has been reached? You have to have the wider interests of the community at heart. Licensing is all about addressing the wider community interests. And you've got to balance those competing interests, the speeds who want to make money and the residents who just want to continue living in the village that they know and love. So in that way, we would suggest that a compromise is reached and that would be the proper outcome. You'd be having regard to the submissions of the residents. You'll say, all right, we acknowledge that you're prepared to give them a chance to show the licensing committee that they can do what they say they'll do. And then we'll look at the matter at a later date. Rather than saying, well, look, we'll give you 10 days until 1 o'clock in the morning, 365 days a year. And if you have a problem with that, then you, the residents, have to come back and review the license. Put the onus on them. Allow them to show you that they can operate these premises correctly. Because at the moment, on the evidence that we have, the premises are operated incorrectly. So a rather long-winded approach, and I'm terribly sorry for taking so long. I've got Trisha G with me, and I'm just going to ask if there's anything that she wanted to add.
No. I just don't speak well, so thank you.
That was all that I wanted to say, and I'm perfectly happy to answer any questions.
Thank you, Mr. Rankin. Any questions, Councillor Panther? Not at the moment. Councillor Brown?
Thank you, Mr. Rankin. You've given us a lot of evidence under licensing objective 3, the prevention of public nuisance. I wondered if you had any objections in relation to the other 3 objectives.
Crime and disorder. So crime and disorder will be dealt with by others who sit behind me. I know that they have certainly been the victims of crime or know people that have been the victims of crime when events have taken place at Betley Farm. But for our own part, we can't say that we have had any experience of crime. Insofar as the protection of children from harm is concerned, I know that Whitmore Hall Estates, there we go, was refused a license outright. They weren't even given a handful of licenses, because what concerned the licensing subcommittee then was the fact that although Whitmore Hall Estates had outlined a plan, there was no indication on the plan how people, for example, children, would be prevented from accessing the site. Now, it may be that the speeds are going to say, well, we're putting up 6-foot-high Harris fencing all the way around. Maybe that they say that. I fancy not.
Interject. I'm reluctant to interject Mr. Rankin when he's in full flow. But really, was this part of the representation that Mrs. G made about protection of children from harm and relating it to Whitworth Hall?
I was asked a question, and so it was just...
excuse me, I remind you both, any questions that come through me, okay? So,
Apologies.
Okay, that's so accepted. Mr. Rankin, would you like to respond to that?
So the question is this, have we any evidence that children have been subjected to injury or harm? Is there some evidence in the future? Well, I can't say that. That's a matter for you. But principally, the peg that I hang my hat on relates to the prevention of public nuisance and public disorder. It's important to remember the word prevention. It's not, have you suffered public nuisance and public disorder? What can we do as a committee to prevent public nuisance and public disorder occurring? That's the point. It's not, well, have you got any evidence? Our response to that is yes, we do, because you've only got to look at the farmers behaving badly to know that 650 people creates a public nuisance. What on earth is going to happen if you're given 1,500 as a capacity?
Thank you.
Anything more? No. Right. I open it up to the applicants. Excuse me, my ignorance. Is it Mr. Cryer? Right. I wasn't sure of your name, so I'm sure you want to get into this. So I'll hand it over to you.
Thank you. Oh, I think I just have a few questions, because most of what I have to say will come in my address and submissions, sir, and so we won't get into a debate, particularly with another lawyer-to-lawyer debate. But just in terms of Mrs. Gee's location, is she about half a mile from the Betley farm or thereabouts?
I'm about quarter of a mile away.
Quarter of a mile, okay. And it's a small point, but the tea room external area, why restrict the outside area to 9 p.m?
Because it's a bricked courtyard and it echoes. And if it is used, and the houses literally abut the farm. I used to live in the house opposite. I've since moved. So we were very aware of the amount of noise that was emanating from the farm generally, especially when the events were on, and especially when there are people gathered in the courtyard. The noise does carry. It is bang on the main road at the front of the cafe. So yeah, it must probably to the residents, 1, 2, 3, 4, 5, 6. There's at least 8 houses very close to the farm that could be well disturbed by that kind of noise.
But not yourself personally, where you live now?
Oh, from the, well, I have not seen an event in the courtyard since I have moved, because the cafe wasn't open when I lived there.
Okay, if I can move on to a question, if I can question one of the points that was made by Mr. Rankin. It may be for Mr. Rankin to answer it really, but I'll leave that to you. You said to the committee that the conditions that have been agreed with environmental health only apply to the 500 plus events. But can I say to you that that is not in fact correct, because condition 4, for example, the noise levels condition, if I can call it that, applies to all events, irrespective of the capacity, as indeed would condition 5, 6, 7, 8, and 9.
It's unclear. They're poorly drafted. I don't want to criticize Mr. Walters. They're poorly drafted. And because the overarching conditions 1 and 2 refer to events over 500, an interpretation of these conditions is that they only apply to events over 500. If you are content, Mr. Cryer, for the conditions to be amended to show that they would apply to all events irrespective of capacity, then we would be content.
We are content with that, sir. I disagree that they're poorly drafted, but we're content for the 3, 4, 5, 6, etc. To refer to all events, to settle that point. I must challenge this, but again, it will be a point of address that this is not a 365-day application so far as the 10 special events is concerned, is it? Just to make it abundantly clear, the only element of discretion about the number of events applies to the theatre shows and the films that Mr. Reuben Speed in particular would wish to put on, which we haven't specified a number for. So the 365 would not apply to, obviously, 10 special events, if indeed the committee agree to those 10 special events.
With respect, that's disingenuous. Set your 10 1 o'clock special events to one side and examine the application that you've made. What are you left with? You're left with 355 days of licensable activities. That's alcohol, that's music, that's dancing, that's late night refreshment. That's what you're left with.
It's incorrect. I think there's a danger here that we get into a debate lawyer to lawyer, sir, but the disingenuous element is referring to 365 days of events, implying that these are the special events. They're not. They're
not saying that. I'm saying
let me finish my point in answer to yours, that we have 10 events that we're asking the committee to approve up to 1 a.m. So far as the discretionary 365 days, and we'll come back to this in submissions, sorry, if we may, but they only apply to the theatre and film shows because we haven't specified a number, and they're limited to 10:30 p.m. in terms of the application or the modified application.
So there will be no music at those events at all?
Well, the nature of theatre shows is, particularly musicals, is that there would be music. Yes.
And would there be alcohol at them?
Alcohol as well.
There we
yes.
go. And you're able to do that 355 days a year, in addition to the 10 that you're already asking for.
So I won't get into a debate on this. I'll submit to you later on our clarification on the position, if I may.
Okay. It's Mrs. G.
I'm sorry, through the chair.
It will be through, it will be given in detail later from when he comes to Mr. Cryer to speak. Mr. Rankin?
So far as the Bethley bonfire is concerned, there's been some criticism about traffic management issues in relation to the bonfire, but yet it's highly applauded. Everyone wants the bonfire. It's been running for well over 50 years. The capacity could be 8,000, 10,000 at that bonfire show. And yes, you accept that. Okay. And the particular issue, was it this year, the traffic accident? Yes. Yeah. The particular issue this year is that there was a traffic accident on the main road, which is why there was a backlog for, I'll accept if you say 2 miles.
Can I just say this? Highly applauded is perhaps the wrong description. Tolerated, yes, because it's been going for so long. We accept that that is part of the weft and the weave of village life. And for as long as Mrs. G can remember, there has been a Bethley bonfire. Last year, not this year, in November, it was particularly bad because there was an accident, and yes, we're aware of that. But that is not unusual. Large numbers descend on the United Kingdom's largest bonfire event. Large numbers come. And it doesn't matter whether there's an accident on the A531, that exacerbated the problems. We know, as a matter of course, that there will be large numbers descending on the village, but we tolerate it. That's the approach that we take.
No further questions. Thank you, sir. Just to reinforce, I will come back on the procedural issue later.
Okay. Mr. Rankin, do you have anything more to add?
Thank you.
Is there any more questions from? Yes, of course you can.
Did you want?
First of all, I would just like to say to Mrs. G, thank you very, very much for supporting the show, because at 2015, at the last hearing, you had your other London barrister questioning me on where the show marquees went because you didn't like it. So that's brilliant. You've supported it. And the show was 164 years old on Saturday, and we had a marvellous day, followed by a charity Sunday lunch yesterday. And the other thing is, Mr. Rankin, when you were talking about the 10s and some of the events that we've had, some of those events have fallen under the five lives, as I call them, on our license now. And also sometimes a bar, and if there's a wedding or something, and sometimes the bar will organise a temp event as well, not just me. Okay, thank you.
Just running on from there, do I take it then that there has at no stage been a difficulty applying for a temporary events notice?
Mr. Chairman, not that I'm aware of. It's just a pain sometimes, like if you're having, so many events in a marquee, which often happens, like next year, the show's 165 years old. So we will be having a show ball. We have one only every 5 years. But when that marquee goes up a week early, somebody might say in the village, oh, my so-and-so's 21, can we use the marquee the night before, and things like that. So that's, like a different 10. And I think on one of my emails, which I think you had a copy of, when we did the events in the shed, when it was Reuben and his twin sister's 21st, because it's Christmas time, the birthday. So we did it in the shed. We'd lined the shed with a marquee that, so we had actually in that marquee 4 events, and it was 4 temp event notices. That was all. It was just to ease a bit of paperwork and a bit of time. And also, whatever event goes on the farm, I always ring Mike Cavell or text him everything that goes on, even if it's a non-licensable event, like the running races, or the cycle race that we have towards Christmas time, or the crib service. The crib service does go ahead in the shed. I always notify him, and I always notify Lisa Roberts in licensing and environmental health. So I do that every time, whether it's licensable or not. Okay, thank you.
Since 2015, when the license was granted, it has been a perfect balance. There's been 1 or 2 apparently noise complaints, but it has been a perfect balance. So all we're asking for is to keep the balance, and the number of events and the lateness of the events that you're asking for is going to upset the balance of the village. Trentham Gardens only runs their event until 10 o'clock at night. And given that you're bounded on 4 sides by property, it has been great not to have to complain or in any way monitor. It's been great, thank you. It's been really good. We're just a little concerned that now, running till 1 o'clock in the morning with those number of people, given the traffic that goes on, the balance is going to go. And can I just say, I don't understand the application that has changed on Friday night that came in late. Are you saying you don't want outdoor amplified music? You just want stage plays, so that bit's gone? Clarity, please.
Yes. So do you wish me to clarify?
That's fine, Mr. Cryer.
Yeah, okay, thank you, sir. So far as the application is concerned relating to theatre productions and films, there will be, obviously, if approved by the committee, some amplification, whether it's of music or of sound from the shows or films, exhibitions, as the case may be. So there will be amplification if approved. But obviously that's when the noise conditions, which have been agreed with environmental health, would apply to those events if approved equally. And they are limited, the theatre shows, the film events, they are limited to a 22:30 finish. So I hope that helps. And
Yes.
Well, your application said from Sunday through all week, every week, all the week of the year. What has happened to something other than those? And you said plus 10 events out of those days. And I'm having real difficulty working out exactly what you're applying for now, because you changed it on Friday.
Yes. Did you, G get a copy of this summary of the details of application. So let's leave aside, shall we, because I think everyone understands it, the tea room and the bonfire. Yeah, the plays and films element of the application. This would allow, it's called regulated entertainment, so that would include music, whether it's live music or recorded. It probably would be both. So that's limited to 22:30 in terms of the time finish for that regulated entertainment. And you see there that we've stated that for any events that are over 499 capacity, they would have to take place in the lower field, the Mere Meadow field. If it's a smaller capacity, then they could, if permitted by the committee, take place on the top field, known as the park or the shed. Now, I agree that what we've not stated in that application is any limit on numbers. And that's where my argument, shall we say, with Mr. Rankin applies in relation to it sort of seeming to be a 365-day license. Now, if the committee consider that that isn't appropriate, then my clients are prepared to put a limit on the number of film shows and theatre productions, but I'll address that at a later point, if I may. But that's the element that is discretionary, because my clients don't know exactly when the productions are going to take place. So they wanted an element of, shall we say, freedom in terms of when those actual events, the theatre shows, film productions would take place. Moving on to the fourth category, that is the special events. Now, they are not 365 days. We're not applying for 365 days. We're applying for 10 of those. And they are kind of similarly restricted in terms of location, subject to the committee. And they're also private events, so that, you know, it's not a kind of walk-in pub garden type situation. They're private events arranged at least 48 hours in advance. Probably most of them would be. And that is the one that we are asking the committee to approve up to 1,500, if that meets with the committee's approval and fits in with the conditions. And that explains the application, I hope, better. Thank you.
It's gone back.
So the special events are 10 and the plays and films could be at any other time of the year and any number. You're not putting a number on the amount of performances that's going to take place.
That is right in terms of the details of the application. I have discussed this issue with my clients and they are considering that to allow sufficient discretion for the shows to be held, because you don't just have a show lasting one day, it just doesn't work like that. And indeed, the numbers need to be at the higher end, more than 500, to put on a proper show for it to be effective financially and, you know, and entertainment-wise. But those events could be limited in number to 50 per annum in terms of event days. So the number of theatre stroke films events limited to 50 event days. So that would, of course, be significantly less than the 365. Sorry, I think, shall I pause? So,
Could I just say that means you want 60 events a year?
Well, it's a permission. It's a matter for the committee, but that would be the application for potentially 60 events during the year if you add the 50 to the 10.
In this sound sensitive site that is more sensitive than Budley, who have got 9, you want 60.
So you're happy for me to continue? The number is not so important, Mrs. G, when you look at the impact. It's the impact that's relevant. What our submission is that, supported by the conditions which have been agreed with environmental health and the police to a degree, but both of them supported by that, and bearing in mind the nature of the events, because obviously there's a substantial difference between a theatre show and you know, a a party type event, bearing in mind the change in the difference in the nature and the fact that the theatre shows, film shows would not go beyond 10:30, that makes it of lesser impact than if you're talking about an open beer garden, for example, where people could turn up 365 days of the year.
Comment in closing.
Any further questions? No. Councillor Panther? Do you have any further questions? Okay, Mrs. Gee and Mr. Rankin, thank you very much. Okay, Matt, if you'd like to invite the next speakers on, please.
Yes, thank you, Chair. Michael and Pamela Lane, please.
Speak through your mic, please, Mr. Lane.
So I can't really see what I'm doing half the time, and I hope I don't knock the water jug off. My name is Michael Lane. I've lived in the Betley village now in 2 locations for 50 years.
Mr. Lane, can we speak a little louder for people that...
I am speaking quite loud.
Yeah, it's just
I don't know whether this one is working. Right. Is that one better? Which one is working now? All right, thank you. I'll start again. I've lived in Betley for 50 years along with my wife, and we've lived in 2 locations, both of which are fairly close together to where we actually currently live and are affected very badly by the noise from these productions. My wife has chosen not to actually speak, but you will see from our submission of objection in our letter that we sent a joint letter in, and on this occasion, my wife and I are in a full agreement, where in many cases we might not be. The situation is now that I feel as though I'm auditioning for a part in Rumple of the Bailey or the Vicar of Dibley, the way this procedure is going, and I feared that this might happen. I've been to these meetings before in the old municipal offices, and it all boiled down to a level of debate about whether or not the decibel level was acceptable. In having to have a noise judgment on this, it means that in effect, the event is noisy. And without doubt, all the things that have been said already are true. It is uncomfortable in noise levels. There is congestion. There is problems with, what shall I say, access for emergency vehicles when the roads are blocked with all the traffic coming and going. So if somebody has, unfortunately, a medical emergency or the house is on fire, the local brigades can't attend in normal sort of speed. Where we've come from was that Betley Show has been a tradition in the village for long before I ever came on the scene. And it used to be held with a little caravan and a tannoy system making public address noises to tell people that the show jumping was starting or what was happening in the marquees at the current time. And it was audible even in areas such as where Mrs. G lives or where I live at the moment. Now we have the modern amplifiers and the sound systems that are in use. The thing is 10 times worse if it comes down to noise. On Saturday, 2 days ago, we had the Betley show. The noise in our garden was such that I didn't have to be at the show. I knew everything that was going on, and I had a Elvis Presley performance that I could listen to as I was tidying in the garden. Now, I didn't ask for that, but it was imposed upon me. The shotgun firing went on from roughly 10 o'clock in the morning when the show was beginning to open to roughly 8 o'clock at night. The sound of gunfire echoes all around the area, and it was a case of you didn't know from which direction the sound was coming. And this has been the problem that we've had, that the likes of Mr. Walters and so on will be genuinely trying to control the noise levels. But the geography of the site is such that you cannot stop the noise. And if you go to a concert, whether it's a play or a pop concert or whatever, you do not expect to be sitting there or standing there unable to hear the performance. Unfortunately, you're sharing it with everybody who lives in quite a considerable distance from the farm showground, as it's called locally. So we have a situation where we are expected to have an entertainment centre to replace the farm in its traditional sense, because I was told at a previous meeting such as this some years ago with the previous licenses that the farm was not viable as a farm and it had to look to alternative sources of income. Nobody in Betley has any hang up with that as a necessity for the Speeds and their family. What it is wrong is that the farm is not an isolated farm. It is not miles from everybody else, but it is right slap bang in the middle of the village between Betley and Rhine Hill. It's really one unit. It isn't other than a whole. And we are forced with the location to suffer any noise, including the Betley show, which we tolerate because of tradition and we think it's worthwhile for one day a year. And as far as the fireworks were concerned, that was applied for on the back of the historic holding of the Betley show on that site, and that it was supposedly following along similar lines, usually held on the nearest Saturday to the 5th of November. The Betley bonfire actually does pose probably far more problems than the Betley show. And then if you extrapolate, as we've found from our experience of the pop concerts, as we call them locally, you can call them what you like, musical events, whatever, it was even worse. And it's very difficult to say when somebody is looking at noise levels, if I do this, turn the stage around to a different way, is it better or worse? For us on the south of the village and to the east, moving the stage, as was made a big song and dance of last time, actually probably made things worse. and may have helped Mr. Cavell and his side of the village, but it didn't help us whatsoever. And so when you look at all this, what we're talking about here is, and it's pointless getting into great detail from my point of view, because I'm not a sound expert, should these events be staged, is it appropriate to stage them in the middle of a residential area? The answer to anybody who has any common sense is, well, it isn't really the right place, but the Speeds can't pick the farm up and move it to the wilds of somewhere. So they are trying, quite understandably, to make a living, but it should not be at the expense of the normal residents. The licensing has been a problem, and we have had very acrimonious meetings in the village hall where people have been outraged, particularly after the first concerts when I think it was Status Quo kicked off. Everybody said they enjoyed it and it was very good. That wasn't the point. The point is, should it have been taking place in that location? The Happy Mondays, as they were called, that did a show on the Sunday of that thing, was an absolute disaster. And they had to stop the service in the church to ask if somebody would go down and ask them to be a bit quieter because they couldn't hear the vicar. Now, these noises measured in decibels to meet the requirement of pop concerts on appropriate land are acceptable, but they're not acceptable in a residential area. I believe every resident in Betley has the right to come home, sit in their house or their garden if they're fortunate to have it, and enjoy their own piece of quiet way of life if that's what they choose. And if a neighbor makes a lot of noise, they will complain. And if the neighbor continues to make nuisance, the police are called, and very soon somebody's knocking on the door telling them they're being a public nuisance. So here we have a situation where most of Betley residents do not know of this license application. I'm sure if I went to Betley now, I could find more people who know nothing about this than do. The parish council have an article in the parish magazine every month. No mention was made of this license application at the time of the publication in July. It does appear a mention in the August edition, but that is too late for anybody to have any objections and meet the deadline set by this authority. Sticking a notice on a farm gate and a small insert in the Sentinel does not convey what is afoot in the village to the majority of people. It is a mistake in the first part, and it caused outrage after the first set of conferences when we met in the village hall at the instigation of the parish chairman to try and diffuse the anger that was present. To give him his due, Mr. Speed did apologise that he hadn't realised it would cause such distress. The then late alderman who represented us as our councillor, David Beckett, was present at this meeting and said that the council had complied with their statutory requirements in law, legally, that the farm gate little sticker and the little insert in the Sentinel, which nobody hardly ever reads now because the edition that came to Betley was sort of printed about lunchtime and was really repeating what had been in the morning papers. And so it was a case of ignorance is bliss, and the same procedure is being taken again for this license application. People do not know what was afoot until it's too late. People were annoyed that the original license was given without any review and critique of whether it caused nuisance before it was to continue. It was given without any limitation that they could hold this license forever. Most people were very annoyed at that and felt it was wrong. That has led to a feeling in the village of distrust amongst the what I would call ordinary residents, and a great many people, including, I might add, at that special meeting, when I asked the chairman of the parish council, had he any forewarning of this license application, he said that he had not, that the first he had known was after the event and the license had been issued. I also said that I thought that, considering that Mr. Speed was a parish councillor, he was in dereliction of his duties to look after the people of the residents in the village. That, of course, caused some angst. And I'm sorry that all these sort of things have led to a feeling that people daren't or won't speak up because they don't want any more unpleasantness in the day-to-day meetings with what are our neighbours and friends. I was the doctor in Betley for a good few years. I treated everybody on the NHS, refusing to take private patients, even though the money could have been useful, because I didn't think I wanted a two-tier system and a disadvantaged section of Betley. The very thing that I don't believe in is what this license application is about. It is about money. The old song that was popular in my youth before television, "Money is the root of all evil," is very, very appropriate in this license application. I would like you to seriously consider the basic point, not what is the level of the decibels, but is it right that these noisy events, whatever you like to call the event, should be even considered for one day above what we've already got, and some of them shouldn't have happened anyway. And so to finish on a sort of rural tone, I would say that if you grant this license permission as it is very like giving the fox the key to the hen house door. It will destroy what is precious in Betley, a quiet rural village, which is probably one of the jewels in the crown of this borough. The mention I noticed of the Whitmore application that never took place, one of the things that I was told at the time was that there was not other than one single road, and therefore it prevented access to emergency services and for the general public to pass through. In Betley, of course, we have a single road. You can't pass through when these events are going on, and unless you go miles around, you cannot get from Madeley to Weston. Thank you, Mr. Chairman, for your patience.
Thank you, Mr. Lane. My question to you is,
yes,
if you could amend this application in any way that would be beneficial to both parties, which would you like to give some indication on that?
Well, what you're doing is posing almost a question of when did you stop beating your wife? The point is that the events are generating nuisance. We can debate, as I say, whether it was noise or otherwise. There has been criminal damage, despite one of the letters of support that I noticed you'd received. I can vouch for the fact that these crowds do generate some people who, like a football match, are not there for the football, and they are trouble. And my neighbour that I spoke to by chance a couple of weeks before all this application was known to us told me that he had had £150 of damage to his car when the no parking cones in the road outside were thrown at it by people passing on their way to the farm. I know the farm can't control all this. They may have stewards on the site, but they can't control the coming and going. People don't arrive by parachute or helicopter. And so when you ask me, what could I suggest would be better? I say this, that we know nobody in Betley would mind anybody in the tea rooms having a glass of wine with a cream bun or whatever it might be that they've chosen to have. We don't mind if there's a string quartet playing quietly in the corner of the tea room. But what we do object is for this noise. The Betley show yesterday on Saturday was not pleasant in our God. And I bit the bullet and thought, well, it's for the tradition of the village. But what we're being asked for now is to put up with similar things that are not for the benefit of the village, they are for the benefit of the Speed family. I have no objection to them trying to make a supplement, if you like, or alternative living to farming. But this imposition on us normal, I think I'm normal, villagers who just want the peace and quiet in their home, just as much as you or anybody else would want in your home, is totally inappropriate. Thank you for your time.
Thank you, Mr. Lane. Councillor Brown, do you have any questions to ask?
No questions. Thank you, Chair.
Councillor Panther?
Yeah, one point, Chair. Mr. Lane, you mentioned you've been in the village an awful long time and you're complaining about various elements of nuisance and noise. Have you previously objected to licensing applications in the past made by Mr. and Mrs. Speed?
I have objected to them when I knew about the application. I couldn't object to them when I had no knowledge of the application, which is what happened when the initial licensing was applied for from what I gather this morning, was 2014 or 15. You can correct me on the actual year. That was when we had the 3 evenings of concert, Friday, Saturday, and Sunday. Nobody objected to that. When David Beckett came to the village hall to explain the position of the licensing authority committee that had given the license, and they'd said they had to give the license because no one objected. No one objected because we didn't know. And so again, later on, there was an extra concert put on for a 4th night when I think it was Will Young was to star, which I'm sure lots of people probably enjoy. But the point was that there wasn't a license for 4 nights, and there was a retrospective application for that license. It had to be done at short notice because the concert was due to start within a matter of days, and they hadn't a license for it. The few people that did know about it, and I was one because somebody told me, wrote in and objected, and only the people that had given written objections were permitted to attend the hearing, which was summoned very quickly because of the shortness of the time interval before the concert was to take place. As it happened, of the small number of people that had objected and knew about it, it turned out that my wife and I were the only people who were able to come to this hearing, like this morning, although it was in the old premises. And a barrister stood up and said, by my reckoning, there are 2,000 people in Betley and its sort of environs. And I'm looking around here now and I don't see many objectors. This kind of bullying is wrong, and I'm not in the slightest embarrassed by it. But I can say that there are lots of people in Betley who would not sit here telling you this, even though they think it, because they are not the sort of person who wants to make a fuss. They want to stay quiet, they want a private, quiet life, and they do not want what Betley Court Farm have in mind, a large entertainment centre rivaling Glastonbury or the Madison Square Gardens for their boxing bouts, or the cinema that's proposed in the open air. I lived for a little while in North America, and I know what the drive-in movies were like there. The screen was on and the picture was on, and everybody sat in their cars and they brought the sound into the car. It didn't go all over the village or the vicinity of the cinema. It was silent outside. I presume that if we had to have a cinema in the open air in Betley, the sound will be generated generally rather than individual microphones and speakers to individual people while they're watching or listening. Is that sufficient for everybody? I think I've tried to paint the picture of how Betley residents feel they are being not heard. I don't know whether you call it human rights or what you call it. They are being abused. They're being trampled upon. And it seems very wrong. And I think that it's fair to say I've reached an age now where I don't think I shall ever be appearing, you might be glad, at a hearing like this again. I have a sight impairment which prevents me from writing notes down and reading what I've written. And so I've had to sort of do it off the cuff. And I'm sorry if I've repeated myself unnecessarily and I've failed to mention something that's more important that I'll think of when I get home. But I think you have probably got the picture. I hope so anyway. Thank you.
Thank you, Mr. Lane. Mr. Cry, would you like to come in?
Yes, thank you. Just a few questions, Mr. Lane.
Yes.
I think it's clear from your written representation and also what you said about your concerns, that really what you were utterly against is the concerts. And perhaps we might include the Betley show and the bonfire as well, but that's really what your core concern is. Is that right?
By that, the question is, do I object to the noise and the congestion?
Yes, and what I'm saying is that, and that's associated with, in your memory, with the Betley show, the Betley bonfire, and also the concerts that were held in the past.
The concerts that were held in the past will not be forgotten by a lot of residents because of the discomfort that they experienced. It's impossible for me to explain just quite how loud, distracting and unpleasant noise is when you are not given any warning or any way of turning it off. If I do that, everybody in here will say, you're disturbing the peace. That is the principle of why I'm objecting.
Okay, I won't press the point. Thank you, Mr. Lane.
Well, I hope you've got the point, because that is, if you're in any doubt, ask me again in another way.
If I can ask you another question.
Right.
It's a little unfair, if I may say so, if you're able to answer this, to say that it's all about money for the speeds, referring to the bonfire, which is run by a committee totally independent of the speeds, well, independent of the speeds, should we say. Obviously, they have connections there, which is run for the benefit of the community. They don't have to hold it, but they do. And secondly, the Betley show, which does not make any profit at all for the speeds, and yet they run it year on year because there's a history to it. So it's unfair to criticize them on the grounds of really seeking money from these events.
Well, they are seeking money from these events that they are proposing. I know Mr. Speed has told me, and I mean, I've known Frank for 50 years. I knew his father and I knew the people that kept the farm before him when it was part of the estate. The late squire was always very keen to have the Betley show continue after his demise. And my understanding, having spoken to Bert Speed's, Frank's father, Bert Speed, was one of the problems was that in order to hold the Betley show, it meant that part of the farm was going to be not usable for normal farming production. And so I have sympathy for that, because it's not something that Betley residents have any animosity towards the Speeds. But what we do have is an understanding that they have to make an income. The farm does not, according to the information I was given by a retired NFU official, have an ability to stand alone. And so they have to make income. There has to be money. And how much money they make, well, will be dependent upon how successful they are at these concerts. To be of a size, as we've already heard this morning, that will make money, they have to be large and they have to be frequent. Otherwise, it is not worth their trouble. And that is, I hope, the answer to your question.
More questions, so you'll be pleased to hear.
Thank you, Mr. Cryer. Any further questions from? No. Okay, Mr. Lane, thank you very much for your time.
Thank you, sir.
Right, how many more speakers do we have?
It's either 9 or 10, Chair. There was one person who made a representation who had originally said they were going to speak, and then they withdrew their application. Sorry, their representation. And I'm unaware as to whether or not they're in the audience today.
That's okay.
Oh, sorry, sir.
Yeah, no, continue, Mr. Cryer.
Just wondering if you have the name of the person who's withdrawn their representation.
Yes, it was Peter Panay.
Okay. I haven't called him down.
No, I haven't called him.
Right, I'll ask you this, Matt, or even Anne-Marie, if you could come in on this. This seeding is going on for a long time. Are you allowed to recess and have a break, come back, or does it remain until it's finished?
We can actually, we can have comfort breaks, we can have a lunch break and resume.
Anne-Marie, I'm very sorry, we can't hear you.
Oh, sorry, is it not letting me speak? I'm on mute. Can you not hear me now?
Okay, apologies to all. There seems to be an issue with Anne-Marie speaker.
Can you hear me now? No?
Yes, we can hear you now.
Okay, thanks. We can have adjourn for a comfort break. We can adjourn for lunch and then continue the meeting once we come back, whichever way around you want to do it. But it has been 2.5 hours now, so we could do with having a little break.
Right, okay. I have a member of the public gallery. Yes, sir. I've just asked the officers a question. Because we haven't been in this for 2.5 hours now, if we were allowed a comfort break, or we have a break for lunch to give everybody a chance to go for a breather, if it's convenient. Gentleman at the back. Okay, in retrospect to yourself, sir, would you like to come and have your speak and your say now, so that it allows you to get off and do your work? There are other people in the same boat as well. Are we going to allow this? Yeah. No. Yeah, we've got no exceptions. Yeah, yeah, that's fine. Matt, if you could invite the gentleman down, please. I do apologise for the echo. If IT are listening, they can jump on that to sort that out, please. That would be appreciated. Could you introduce yourself, please, sir?
Yeah, I've got quite a loud voice, so I'm not sure whether I'll need much amplification. My name is Bill Dixon. I'm a resident of Betley. I live on the main road, and that is significant. And I live right opposite the Swan Public House, which doesn't have a beer garden, but does have people sitting outside on the main road within 10 meters of my front door, 365 days a year. And I knew that when I bought the house. So the first point I want to make, and I will be very brief because I've been critical of previous speakers for saying rather too much. The first point is that despite what other speakers have said, Betley is not this bucolic back of the end of the world village. It is on a main road. And anybody who bought a house in Betley, not realizing the implications of buying what is basically a strip development of Betley and Rhine Hill along the main road, was simply not paying attention when they bought their house. So it's not some rural backwoods place. It is a residential area, yes, but it's on a main road. So the other important point here is we have to look at this application in its wider context. The speeds, as I said in my representation, are trusted and valued custodians of not just the farm, but a community asset that provides a huge amount, not just to the village, but also to the wider community of North Staffordshire. I've been involved in running cross-country races over the last 2 years at Betley Court Farm. Races which are clearly of a benefit to young people. We have at those races young people from the age of 9 upwards. This is of a benefit, not a danger to young people. It's a benefit to young people. And we can't expect the speeds to provide this community resource unless they're also able to run a viable business. So the idea that they're doing this just to make money is, frankly, it just appalls me. I can't believe that that was said. I also earn a crust as a professor of criminology at the University of Nottingham. So I do know a little bit about crime, disorder, and nuisance. And it's important to make a distinction between nuisance and crime and disorder. Most of the focus today has been on nuisance, as it quite rightly is. The allegations of promoting crime and disorder, there's just no evidence. If you want to go and look on police.uk, you can see what the crime figures are like for Betley. It's basically non-existent. Somebody had a lawnmower stolen from their shed 5 years ago. And social media, Betley's Facebook page went mad because this was a crime wave. So when crime and disorder, we can forget about it. Nuisance, yes, but nuisance has to be seen in a balanced way. And there's been a lot of talk about balance. And I want to correct that balance by setting a level of public nuisance, yes, when there's a 2-mile queue to get into the village. But this is not going to happen when events are by and large limited to 1,500 people. We're talking about at most 1,500 people. That is not going to lead to traffic backing up to Wychwood Park, or in one, there was a statement that it was backed up to the motorway junction. That happened perhaps once. It's simply not going to happen again. So there's a huge amount of scaremongering going on here. What I want to end with is what I think is the most important point here, is if this was some faceless corporation wanting to run money-spinning concerts, I would be objecting. It is not a faceless corporation. It's people who we know, who we trust, who we live with, who have run this farm for 50 years in the family. If we can't trust the Speeds to do the right thing, who can we trust? There's been a lot of talk about trust. Frankly, I trust the Speeds much more than I trust some of the people who've spoken to you today and who've represented themselves as speaking on behalf of a silent majority in the village. Well, I'm not part of that silent majority, and I'm here to say that I completely support this application as the best way of preserving a community asset. And I'd just like to end by saying in paragraph 6 of the officer's report, there's mention made of the 4 corporate priorities that you have to bear in mind. And I'll read the first 3 because I think they're very relevant to this application. Local services that work for local people, growing our people and places, a healthy, active and safe borough. All those boxes are ticked by the Speeds, by the business that they run at Betley Court Farm, by the community activities that are supported by that business. And I'd urge you to support this licensing, to approve this licensing application. And thank you very much indeed for hearing me slightly out of turn. I'll go back to earning my crust now. Thank you.
That's fine, Mr. Dixon. Mr. Dixon, if we can, please be seated.
To ask me a question.
I don't particularly wish to ask questions, but I do have to open it up. Councillor Brown.
Thank you, Mr. Dixon. You have put forward arguments to say that the change to village life and disruption will be minimal, but in many ways we're predicting that, aren't we? Because we're not exactly sure. Can you give us any more information on what you're basing this upon, please?
Well, I think we're all agreed that the bonfire does cause some disruption, but that is an event that's attended by a minimum of 8,000 people. What we're talking about now is events that won't be attended by more than 1,500 people. Now, just as an example of something I've got direct experience of, last autumn 2021, I was I was one of the people who organised a meeting of the Birmingham and District Cross Country League at Betley Court Farm, which had 1,200 runners at it. And as far as I'm aware, it went almost completely unnoticed by Betley residents. There were no objections. There was nothing. Okay, alcohol wasn't served, but we're still talking about traffic and large numbers of people. That's the evidence I use. Most of these events pass without anybody really noticing them. And to extrapolate from the bonfire to what is currently being proposed is frankly ridiculous.
Thank you, Mr. Dixon.
Mr. Cryer and the applicants.
I think just one question. Thank you, Mr. Dixon, for your support today. But just in terms of these events that have been held, you've been aware of them, just let's say over the last 5 years. So ignore the concerts held back in 2014, was it 2015, and ignore the bonfire and the Betley show, which everyone's talked about. But any of these other events, these private events, the weddings, anniversaries, have they ever caused you any nuisance at all?
No.
Thank you.
Thank you for your time, Mr. Dixon.
Thanks very much.
Is anybody else in the gallery like to come and speak because they need to get off? Just yourself is okay.
Say this, but I know that you have rules of procedure, and the rules of procedure currently where the representatives, the interested parties should make their case. We have witnesses representing the interested parties that have to lose as well. And I wonder whether we could revert back to the procedure that we were. And if they.
Okay, Mr. Rankin, but that's why I asked our legal officer, because I don't know. I've never been on a licensing meeting that has gone on for this long. I was just mainly asking the question for people to have a comfort break of some description. So, Anne-Marie, if you could come in, please.
I didn't hear what was said because he wasn't speaking into a mic.
Yeah, we can't hear you again, Anne.
What, can you not hear me? Sorry.
No. IT, can we?
Can you hear me now?
In, please.
Can anyone hear me yet? Can anyone hear me? I'm muting and unmuting, but it's not doing anything. I'm still here.
Yeah, we can hear you now, Anne-Marie.
All right. Yep, he's just said try now. I didn't hear what the gentleman was said because he wasn't on a mic. What is it that we're looking for?
Right. Okay. Mr. Rankin, would you mind coming and putting your point across again, please?
The issue was this, that there are rules of procedure, and the current rules of procedure were that the interested parties were to make their case. And we were going through that, and then Mr. Dixon indicated, although he wasn't part of the representatives against the case, was in support, could he be heard out of time? And permission was granted for that. There then followed a number of other requests from people who were on Mr. Cryer's team, asking if they could be heard too, upon the basis that they have to leave early. We also have in our camp a number of people that wish to leave early as well. And my request simply was this: could they be heard first according to your rules of procedure?
Sorry, if it helps, I don't have any objections to that at all. Everyone who wants to speak and has to get away really should be heard, as you know, even if that means holding back lunch, so to speak.
Yeah, that's
Thank
fine
you.
with me. But Anne-Marie, if you could just come.
Yeah, if I could just suggest that we have then a 5-10 minute comfort break and then continue until we get to a point where we could adjourn for lunch.
Can I just check that those who are supporting would be okay with holding off? I think there was a lady before who. Yeah. Yes. Are you okay? So how long can? Sorry, sir. So can we hear this lady? Sorry, I don't know her name. Can we hear her now before the comfort break?
Mr. Rankin, are you happy with that?
Well, it's not up to me. There are those behind me that have to leave, and I don't know how urgent that is.
Chair, we've been going on for nearly 3 hours now. I think we need a comfort break now for 5 minutes and then everybody back.
Okay, I will take the recommendation from my legal advisor, and we will have a 5-minute comfort break, and then we will come back in 5 minutes and continue.
Okay. Thank you, Chair. Is everyone back now?
I think we're all in the room.
Thank you.
Yes. Okay, we'll continue with this. Matt, if you'd like to ask the next person to come down, please.
Yes, thank you, Chair. Melanie's sought some sort of availability from the people who said that they need to get off. So what I'm proposing, Chair, is that we call Debbie Smaldridge next, and then following on from that, Mr. Rankin and his witnesses that you wish to attend, if that's acceptable.
That's fine, Matt.
Thank you, Chair.
Thank you, Mr. Chair, and thank you, the committee. I'll keep this brief, and thank you for being so flexible as well with people's commitments. Yes, that's absolutely fine. So there's a terrible echo. Can we do something?
Yeah, the echo is because we put Anne-Marie back on. IT seem not been able to sort that out, so just have to roll with it, unfortunately.
I'll muddle on. So I'm also representing myself as a member of the community in Betley. I live in the village along with my husband, and we've both been there for 7 years. I live quite close to the farm, it's on Church Lane. And one of the reasons we actually moved to the village was the sense of community that Betley has. And the majority of that, from our experience, is very much centred around the Speed family, what they do, what they bring to the village and the local community. I completely understand that everyone has a different view, and everyone's entitled to that. But mine and my family's view is that we very much support what's been presented here today in terms of the application. I also want to make clear that there have been some leaflets circulated in the village, which I really did not want put in my postbox, which outlined how we should object to this application. So one of the main reasons for being here actually is to say that that leaflet misrepresents the application in my point of view, and has probably also misled others to then make an objection. I think the mic, oh, there we go, that's better. Don't like hearing myself in stereo. So I think that may well be why I think 7 people have actually withdrawn their objection. Obviously that's hypothetical, but I think that leaflet was incredibly misleading, and I fear that people have, as we've heard this morning, been confused by what was actually meant by the application. So I hope that people having the opportunity to hear that this morning, it's actually clarified that for quite a few of the parties here. I think there have been occasions where people have talked about Betley Bonfire, the Betley Show. I don't think we can talk about these things in isolation. I think what we should say, and what I am here to represent, is that I fully support and trust the Speed family in everything they do, whether that's around protecting the village, the people in it, the environment, all of those things. I think they actually encourage the community to come together. I think it's an incredibly safe environment for families, and there are not so many of those in this day and age. And we thoroughly enjoy being part of village life, and you know, I think we're very privileged actually to live in a place like Betley, and our choice of the location was very much influenced by what was available there. I think the other thing that the family should be commended for is their inclusion and of the community, but also their diversification as farmers. should be applauded. And I think they've done what they need to as a business, which has also attracted people and financial benefits to the rest of the community. So we're one of the few villages locally to still have a shop, a post office, to have pubs, and have a choice of where to go to eat in the village, which is fantastic. And I think part of that is about what is represented in Betley, and the Speed family and what's arranged there is very much part of that picture. And I wanted people to hear perhaps a broader view of some of what is held at the farm. It's not just about concerts that happened a long time ago. The here and now is that there are fantastic events that are very, very inclusive to everyone in the community and outside as well. That's all I wanted to say. Thank you.
Okay, thank you. Any questions, Councillor Panter?
You've had no objections brought to you, particularly nuisances. Have you suffered anything from nuisance or damage at all?
Not at all.
Councillor Brown?
Thank you, Chair. As someone who lives in a rural village myself, I was interested in your points that they have contributed to the infrastructure, as in there's shop, pub, etc. Could you just say a little bit more about that?
Yes, absolutely. I think other villages have had some of the facilities we still have, and they've lost them. And I believe that some of what's arranged via the farm and what's available to people, it brings people in, particularly now the addition of things like the tea room. There's a full breadth of things for people to come to. It's not just about the concerts. And I think that's definitely attractive to the majority, actually. And as I say, I felt it was important that someone said that.
Thank you. Was it Mrs. Walsh?
Smaldridge.
Smaldridge, sorry. Thank you, Mrs. Smaldridge.
Thank you.
Mr. Croy?
Questions, thank you, sir.
Does anybody else have any other questions? No? Okay, thank you very much for your time. Matt, if you can to bring the next speaker down, please.
Thank you. Yes. Mr. Rankin, you had some witnesses that you wanted to bring on.
Okay, could you introduce yourself, please?
Yeah, just the central one.
Now, am I going to echo on this? No, right. Hello, everybody. Good afternoon. My name's Liz Middleton. I live on Main Road at Tower View, exactly opposite the clock tower to Betley Court. I heard about this planning application not because I was notified personally through the village or found out in any way other than the poster, the leaflet which was put through our doors. And I was horrified. I was horrified to think that somebody living in the village could actually apply to have a license to sell liquor for 12 hours of every day, or have liquor available for 12 hours every day, to one short of 5,000 people, 365 days a year, and to apply for musical events of the kind we have experienced in the past. I sent an objection, a written objection, and Melanie Stedman very kindly sent the report pack through. So I read all the pages. I've read it through a couple of times. I've noted the regulations, I've noted the planning applications, and what's been said before on behalf of and in objection to this event. It seems to me, in the very first instance, that the conditions of natural law and human rights are violated by an application of this fashion. Everybody in the village is entitled to enjoy the peace and quiet of their home without exception, without having horrendous noise inflicted upon them. My objections primarily came because of my experience of the previous musical festivals. We didn't have anybody from the council come to tell us about it, or any inquiries as to how we had experienced it from anybody, except we did have one of the local radio stations came round and actually interviewed me. I don't know how many other people they interviewed. I described to them my experience of what we heard in our house. We could not go outside, being inside our home with our doors closed and our windows closed. The experience of the amplified sound was like being personally banged on the head with a metal dustbin lid, rhythmically and repeatedly for all the duration of that event. It was totally horrendous. So when I read that this application from the lovely Speed family in the village had been made to inflict, they were asking in essence for a blank check to do that to everybody in the village for every day of every year in perpetuity. To my mind, that was monstrous, totally monstrous. And when the planning application committee sent out these planning report booklets saying we're operating on a principle of do as you would be done by, in essence, not to inflict on other people what you would not like inflicted upon you. You have to rule this application out right from the very beginning. People are entitled to the quiet enjoyment, peaceful enjoyment of their possessions, and this application seeks to remove that from them. My primary objection was to the horrendous noise. Secondary to that is the disruption, not just because of the traffic, although, I mean, I personally sat in traffic queues 2 hours long to get from the end of the village to my home. But it's not just that. It's not even what goes on, however carefully it might be controlled on the grounds of the farm. It's the exodus of the event participants into the village. I have experienced swarms of them coming down from the hand and trumpet end of the village. I've actually had to hide my grandchildren behind the buildings and behind me because people were coming down shouting, swearing, fighting and carrying on. Totally dangerous. The professor gentleman said that there was no incidence of damage. Well, I can tell you from my perspective, where we live opposite the clock tower, we have had our hedge broken, our next door's hedge completely broken. Clock house tower across the road from us have had a concrete decorative urn stolen from outside their gates and thrown over the high wall, 8-foot plus wall at the back of our house. Now, had it hit somebody, it would have killed them. It was big. We have had what seems to be something the size of a cider bottle or a pint mug smashed through the windscreen of our car. My husband's car had an imprint on it, which looked as if it was an axe head in the hard double skin just in front of the windscreen and before the bonnet, this deep. We heard noises, bangs, thrown objects. We rang the police. Police said, just stay in your house and don't go outside. Nobody came to investigate that. Pardon me, just while I take a sip of water. Thank you. I know that other people down the village have reported in their written submissions things that have happened to them and on their property and damage which has taken place. If we took a very conservative estimate of only 10 instances of vandalism on a 3-day event, having 499 people, if we round up figures, we can multiply 10 events and scale it up by a factor of 10 to 5,000 people and scale it up to 365 days of year. We're multiplying again by 120. To my shaky maths, that gives us how many? 120 times 10, 1,200 times 10, that's 12,000 events of vandalism per year. Everybody's used to event prediction modeling in these COVID days, and we're not saying that everybody that attends these events is a vandal or can't control themselves. But that amount, that sample of bad behavior that's spilled out of the events on the farm into the village is something that is intolerable. And the people who live along the main road and close to the main road, those are the ones who are most at risk. I've got a friend who's a widow now. She lives in a cottage on her own. She's terrified of these people swarming through the village. We should not be expected to put up with that sort of thing. There is no police monitoring of the people who attend these events when they come out and come through the village. That aspect of public safety was not addressed by the report from Daniel, the Environmental Protection Officer, and the report that was submitted in the report pack from the policeman. He didn't address that issue of public safety either. And part of the licensing committee's responsibility is to make sure that people are not harassed and they're not disturbed unduly by something which is an event imposed upon them. Asking for sanction to put this application forward is a horrific thing. And I would point out that the application, which had its closing day on the 19th of July, was a planning application. It did have, not a planning application. It was an application which did include in it the provision of selling Prosecco or whatever in the tea rooms. But the gist of the whole application was to apply for a license to have 4,999 people in at events on the farm on 365 days of the year, and with alcohol to be made available in effect for 12 hours of each of those days. And that mix produces problems. It doesn't need very many bad eggs to attend to generate on that basis a whole lot of problems for the people living in the village. Nobody has a problem with the tea room. That is not the issue. The basic issue is the loud, horrendous noise, because whichever way you turn it is going to affect somebody. It isn't an issue really of how many people are going to attend, because if you're going to have amplified sound systems, it can be a few people listening or many. And if it's going to be many, as Jane suggested, she needs to bring her numbers up to make these events pay, then the noise is going to be loud. The Environmental Protection Officer said it was going to be at speaking level on the boundaries. No boundaries have been designated. No noise sensitive points have been designated. But my understanding from looking at the CDC noise levels is that we're looking at a spoken level is of 60 decibels. So that's not the kind even of the amplification we've got through the microphone speakers in here. That's less than that on the margins. And I cannot see how an application for this license can go through on the basis of the application which was made, and a separate license needs to be applied for, which specifies a minimum of the noise levels and what measures are going to be taken to monitor them. Shouldn't be a self-monitoring event, should it? It needs to be monitored by someone who is impartial. We cannot have a blank check. You can do whatever you want, whenever you want, and we've got the license to prove that we can. That is a monstrous imposition on anybody who lives in the village, on the main road, or in any of the cul-de-sacs, or any of the little lanes down towards Common Lane, where people live, and this noise is imposed upon them. The village, in the middle of the village, is not a place to hold large-scale, loud musical events. It's inappropriate. Thank you.
Thank you, Mrs. Middleton. Councillor Brown, do you have any questions to ask?
Thank you, Chair. Mrs. Middleton, you mentioned swearing and shouting that you were afraid of your grandchildren hearing. Could you just confirm what the event was and the time of day that that occurred?
I can't specifically tell you which particular event it was. It was in the daytime. It was an event held at Bethley Court, and I got my grandchildren, two grandchildren, granddaughter and grandson, when we were in the playground behind the village hall. So it was not a nighttime thing.
Thank you.
Councillor Panther.
Yeah, thank you, Mrs. Middleton. You make mention of the children's playground bordering onto Betley Court farmland. Are the children in regular use of this playground when the events are going on during the day? Because I wouldn't have thought it'd be in use at night when the noise and the drunkenness comes.
Well, I just explained to you that the event that I experienced with this tide of people coming down the road was actually in the daytime, and the children were playing in the playground in the daytime. It was not something that happened in the evening. I wouldn't certainly let the children out in the evening.
Mr. Cry.
I think just one question, please, for clarification. It's clear from what you said about this event that we're just discussing, were you referring to tide of people? This will have been the concerts, will it, that were held in the past?
Yes,
Yeah.
it was the
Okay,
initial
thank you.
event.
Does anybody else have any further questions? No? Okay. Thank you for your time, Mr. Middleton.
Thank you.
Okay, Matt, are there any more speakers that need to come down to urgently get off?
Sorry, is Mike Prickett still? He's had to go. Okay. In which case is Peter Panay. He had to go as well. Okay. Peter and Jane Ainsworth. Thank you.
you cope with this both together? Here's the one you've got to watch. You want to start?
We're Peter and Jean Ainsworth.
Hello.
And we live on Lady Gates, which is just behind the main road in Betley. And we've lived there for 29 years.
You want me to carry on?
Yeah.
That's okay. We actually moved to Betley from Hong Kong, where we'd lived for 12 years, I think. And it's an aside, but Hong Kong is, as you probably know, is a very crowded place.
That's what I said.
Sorry.
That one's not working.
All right. And people learned to get on together because you had to. We found Betley by accident. We'd never heard of it before. We originate from Manchester. We fell in love with it very quickly, as lots of people do. We didn't know when we moved in that there was a show and a bonfire. When we found out there was, we were delighted. We've never missed it, as far as I can remember. We used to go there with our 5-year-old daughter, and we never felt she was at any risk. She loved it. We've been regulars ever since. As far as the Speeds are concerned, not only do they do what they do for the good of the village, but it's really quite unpleasant to hear them indicated to be greedy and money grabbing. What's not been mentioned, and again, it's an aside, but every year the church have what they call a rogation walk, which is a tradition. I'd never heard of it till we moved to Betley, where you walk the farm and see all the things growing and so on and so on. And every year Frank leads that walk and explains to people what's going on. And then we end up at the house of the money grabbing Speeds, where they lay on refreshments and the best cakes you've ever tasted at no charge for everybody who's done the walk. That's the Speeds that I know. We've never had a problem with the show or the bonfire. The concerts, I think the very first one was Status Quo, and I don't particularly like Status Quo, so we didn't buy tickets. But in the evening, I was able to sit in the garden and listen to them free of charge, and I was fine with that. It just, I don't know, I'm not a young man, but I really don't mind loud music within, certain sensible times. We live about 20 meters from the main road, so we're not as close as some of the complainants here. But we've never had a problem with any of this. And it was a surprise to see this anonymous leaflet come through the front door, through the front letterbox. And it misstates, in my view, it misstates what's actually being requested. And it chivied people to complain and to do what they're doing and object. And from the communications we've had through many means and so on, with people in Betley, it's a relatively small proportion who are opposed to any of this. It's just such a shame, and it's caused a lot of ill will and ill feeling in the community, which was always very harmonious. I'm just sorry it happened.
I would also like to say we had our daughter's wedding in the farm in 2014, and we had people come from the south. She was at Bristol University, so she had people come from Bristol, Manchester, and there was a good 120 plus people, and I don't think it made any noise whatsoever in the community or caused any disruption, but we're very grateful to them because it was a lovely day.
I think that's enough.
Okay, thank you, Mr. and Mrs. Ainsworth. One question I have for both of you. How would you feel having a loud concert on every day till 1 o'clock in the morning, 365 days a year? I know that is not the question. I know that's not the application. I'm just asking that question to you to give your perspective on that question.
The answer is inevitably no. We wouldn't want a loud concert every day of every year. But what we don't mind is loud concerts now and again, because that's rubbing along with other people and being tolerant.
But also we do know that Mr. and Mrs. Speed and family would not do that.
Okay, thank you both. Councillor Panther, you know anything to
I'm
add?
a little puzzled about one aspect. You seem to be in fully support of Mrs. Speed, and yet you call them money grabbing.
I was being ironic, sorry, because it's been alleged
Yeah,
that they're money
yeah,
grabbing.
I thought so.
Exactly the opposite. They're just not those kind of people. Sorry if I.
We're also church members of St. Margaret's Church, and what the Speeds do for the church is absolutely unbelievable. The crib service is every Christmas Eve, and it's for families with young children. And what they do for us is amazing, and we're very grateful to them. Please don't stop.
They undoubtedly care a lot about this community, about Betley. You know, they go back a long way. The family goes back a long way. And it's clear that they care. They're not doing this for their own gain. I mean, they've got to make a living. And as I understand it, it's not always that easy to make a living out of farming nowadays, unless you're Jeremy Clarkson.
Councillor Brown.
Basically, I mean, he knows the ways, doesn't he?
No questions, thank you.
Any questions from
No
you, Mr.
questions
Cryer?
from me, thank you. Sir.
Does anybody else have anything to add? No? Okay, Mr. Ainsworth, thank you for your time.
Thank you very much for the opportunity to speak.
Do we have any more urgent?
Thank you, Chair. I don't believe we have, no one else has notified us any urgency. However, we do have.
How many more speakers?
1, 2, 3. We have 4 further speakers.
I will put this out to all. If anyone would like a break for luncheon, then I will put that out. If we will just want to continue and get through this, I'm happy to do either or.
I'm happy to continue.
I'm happy to continue with a small comfort break.
Small comfort
Only
break.
because I didn't take the opportunity the last time to visit the conveniences.
Okay.
Yeah.
If we allow Mr. Cryer a small comfort break, if that's okay, so he can go and fresh enough. We're all happy to continue with this until the conclusion. Yep. Anne-Marie? We can't hear you, so just give us a thumbs up or a thumbs down.
Can you hear me now? Can you hear me now? 10, 20 minutes.
You want 20? You want a 20-minute break?
Yes, please. Yes.
The gallery, we happy with that? Yeah. Are we happy for 20 minutes? Okay. I'll ask IT to put us on pause or at least stop recording, and we'll revert back at 2 o'clock.
Okay. Perfect.
Okay, everybody, I think we're all here. Okay, we'll continue with the discussion. Matt, if you'd like to bring the next speaker down, please.
Yes, thank you, Chair. Catherine Ball.
Hello, my name is Catherine Ball. I live on the main road in Betley.
Nobody can hear you.
Sorry. I live on the main road in Betley.
No, it's still
No,
nothing.
try this one.
No, I can't even hear myself.
Which one? This one? Yeah. I've got an echo though.
Rob, can we sort this echo out, please? Hopefully it's no, the mics have gone completely. Yeah, trying now. No, still nothing. Okay, still an issue with the mics. Not hearing any echo down here. Okay, I'm just going to pause the meeting because IT are going to come down to sort out the microphone issue. Okay, looks like we're all good to go. Please.
Sorry.
My mic's off. Yeah, we were aware of that with Miss Ball. Are we all happy?
Can you hear me?
Can
Yeah.
everyone be heard? Okay.
Okay. My name is Catherine Ball. I live Edgerton House, Main Road in Betley. First of all, I just want to apologise. I'm in the middle of a migraine attack, but I've taken medication, but my coherent thoughts are not always there. So just bear with me. I've written down some notes, so that's what I'm going to read from. So thank you very much, firstly, for the opportunity to speak. I will try to be as succinct as possible. I live within a relatively close distance from Betley Court Farm and a number of the people who have made representations here today. I understand that the council will make a judgment on the licence application on the basis of 4 distinct areas, using facts rather than what if this or that may happen in the future. Based on the council's criteria, I am in full support of the licence application. The prevention of crime and disorder. I have lived in Betley for 25 years and have never experienced crime or disorder to either myself or the village as a result of events held at Betley Court Farm. I do not consider crime and disorder to be a threat as a result of this application. Public safety. I am aware from personal experience that events held at Betley Court Farm undertake a public safety risk assessment. I have never experienced any public safety issues in 25 years. I do not consider this to be at risk in the future. The public safety is always at the heart of any event held at Betley Court Farm. The prevention of public nuisance. I do not consider public nuisance to be a problem with the events held at Betley Court Farm, and the very few complaints received uphold this. The noise disruption to me is minimal, barely 0, and I feel has been exaggerated. I live on the main road and it does not cause me a problem. The protection of children from harm. This licence will not put any children at harm. Rather, the events at Betley Court Farm over the 25 years, to my knowledge, have all been safely run and the children have been fully protected from harm. I therefore do not consider that there is a threat to children being harmed as a result of this licence application. As we've heard so far, this licence application is being segmented according to individual people's own interests, and as it has been said, should be looked at in its totality. To that end, there are a number of points I wish to make. Betley Court Farm hosts a number of charitable events, such as the Betley Show, Betley Bonfire, charitable balls and charity lunches. None of these benefit the Speed family financially. Betley Bonfire is not a business, as identified by one objector. It is a community fundraising organisation with the community at its heart. All of the aforementioned events are run by volunteers. Betley Bonfire alone has provided groups, organisations and charities within the village of Betley, Bolterley and Rhine Hill with substantial and I believe around £200,000 worth of funding over the past 12 years. The Betley Bike Ride, which has used the Betley Court Farm, has donated £120,000 to local charities or local charities with a link to local people. I find it incredibly hypocritical that a substantial number of those people objecting to the licence have either made applications for funding to the Bonfire Committee on behalf of organisations, or they or their family have been the beneficiary of funding made to a village organisation or group by the committee. It is also hypocritical that some of the objectors have attended Betley Show, put entries into Betley Show, judged at Betley Show, attended Betley Bonfire, or attended charitable balls or musical events on the grounds, and they are now objecting to the licence which is required for those events to take place. The personal character attack on Reuben Speed within one objection letter is disgraceful and compounded by the fact that the statement made is factually incorrect. At the Parish Council extraordinary meeting held in July to discuss the licence application, 31 residents attended, 1 person abstained, and 30 residents were in favour of the application. No one objected. There seems to be, I want a partial part of the licence to be agreed or approved, or not all of it, according to individual needs. The solutions suggested by some representatives here and other people are, I would like to keep the nice activities that I like to attend, but stop those activities that I do not like to attend, i.e. I want my cake sliced up according to my terms, and that is how it should work. In summary, I would like to paint you a picture. It is based on the facts. The facts that Betley Show has been going for about 165 years and was obviously here well before any of our residents. It is the Betley Show Committee who resurrected Betley Bonfire. Fact that Betley Bonfire has provided funding as recent as 2022 to many of the objectors of their family or organisations that they are involved with. Fact that Betley Bonfire will use the same licence the objectors are requesting that you now turn down. So my picture I want to paint is this. A man decides he wants to buy a house. He buys said house next to the church. He discovers that the church has bells and provides services that benefit both the congregation and all the village residents. He decides that too many people will want to come to the church services for his liking. He decides the church bells are too near his house. He decides that the church bells are too loud. He decides that the church bells are too frequent. He decides that his needs supersedes everyone else's. He seeks to have the services stopped. He seeks to have the bells silenced. In the meantime, the man attends church services, accompanied by the ringing of said bells. He gets married at the church, accompanied by the ringing of the said bells. He has children christened at the church, accompanied by the ringing of the church bells. He has his funeral at the church, accompanied by the ringing of the church bells. Finally, he is buried at the church underneath the very same church bells he objected to. Why? Because throughout life, some people's overriding motivation is purely themselves rather than considering the bigger picture. Thank you.
Okay, thank you. Councillor Brown, any questions?
Thank you, Mrs. Ball. You've given us a good list of community activities that are very beneficial. Can you tell us what you think will change? What will be the difference if this licence is granted?
I would hope that the community spirit that is within Betley and is one of the reasons why Betley is such a lovely place to live will continue. I don't think it should change. I don't think the community should change. I think that we should all pull together. And unfortunately, some people with certainly with regard to the anonymous leaflet that went round has caused divide. And that's very, very sad. Unfortunately, I don't think that it will change anything. I think that we are a community. We are a community that pulls together when we need to pull together, and we pull together exceptionally well. If you choose not to go to any of those events, or you choose not to join into any of the groups, then people will always do that. People won't change.
Thank you very much.
Anything further to ask? Councillor Brown? No questions, Councillor Manter? Mr. Cryer, anything from your side?
No questions, thank you, sir.
Okay, Mrs. Ball, thank you for your time. Okay, Matt, we could invite the next speakers down, please.
Thank you. Mr. Ian Ashbolt on behalf of Elizabeth Ashbolt.
Please forgive my frailty, I'm on medication.
Okay. Mr. Ashbolt, continue, please.
Right. Thank you very much. I very much like to support the application that's been made. All the time that I've lived in the village since 1983, I've been very much aware that the community life, community spirit was very much driven by the efforts of the Speed family and their generosity in providing facilities for events to take place. I'm not aware that they've ever done it for any reason other than wishing to contribute to a community life. I'm a strong believer in, I happen to be involved with the Parish Councillors Association of Staffordshire, and I've long advocated that it's up to individual parishes and their councils to try to improve the quality of life, to encourage people to actually participate in that village life and to be communities rather than just dormitories. And I often cite as an example of that, Beckley. Beckley, in my experience, has always punched above its weight, set an example to others, and it's a place that I'm very proud to live in and to call home.
Okay, thank you for that. I have no questions. Any questions, Councillor Chanter?
Have you or any of your immediate neighbours suffered anything from the adverse effects of these shows, damage, noise disturbance unduly?
Certainly not that I'm aware. Clearly, people are aware that the event is taking place. For example, the bonfire. There are exceptional levels of traffic coming through the village. Anyone who's got anything about them is aware that that's going to be the case, and if they need to avoid it, they plan to be out of the village at that time. I've never met anybody in the village who wants the event to be stopped. They've never presented rather any cogent argument as to why that should be the case.
Councillor Brown?
No questions, thank you.
Mr. Cry, you or your members have anything to?
No questions, thank you.
Okay, Mr. Aswell, thank you very much. Okay, Matt, invite the next speaker down, please.
Thank you, Chair. Mark Morris.
Are we on? Good afternoon, Council. As you just heard, name's Mark Morris. I'm now at least 4th generation of our family to live in the village. I've also produced the 5th generation of our village. Betley, all my life, mum's life, grandparents, been a very, very vibrant village. And that is the reason people come to live there. The heart of the village is at the Speeds. It is Betley Court Farm. As you've heard many times before me, the show has now been on for 164 years. That took place on Saturday. With regards to the licence and wanting 1,500 people there, we had probably about 5,000 people there on Saturday, and there wasn't one traffic incident. There wasn't no queues. The bonfire held last year, there was a queue. The roundabout was closed at Western Roundabout, and that was the reason for that queue. We always have queues at the bonfire, but like people have said before, we have given over £200,000 away. I am the vice chairman of Betley Bonfire. I'm on the show committee. I founded the bike ride, and the show itself struggles financially because it is a non-profit making organisation. And for us, thankfully, the Speed family don't charge us any rent for that. In support of the shows, we do put charity balls on. Again, no financial gain from the Speed family, just a headache. When people have said before me that the village didn't know about this licence happening, I personally put the notices up and I know where they are, and they're very visible. The Facebook page of the local village, a lot of activity has been going on that. My mum put on a post that she was upset that all this has got to where we are now because of the heritage of what we've come from. There was over 210 likes on that page. There was 103 comments in support of it. We're in an electorate of 1,200 people. At the village hall, there was 31 people there for it, 4 against. So the gentleman behind me that tells me he has 2/3 against and 1/3 of the village for is nonsense. The other things are that we have been there for a long time, and unfortunately the people behind me possibly don't understand what the Speeds do to the full effect and how they help. The lady behind me that has had the bonfire there as long as she's lived won't have to think back very long, because I don't believe she's been there over 10 years. Like I said to you before, my family's over a century old there. With regards to comments about the safety of children at the events, the last concert would have been 2016, is that right? 5 years ago, 6 years ago. My children are now 8 and 9. Both of them attended. Both of them were safe. There was certainly no issues with safety. Outside the ground, onside the ground, I have a lot to do with helping out. I've had dealings with Darren Walters, and for people to say that he wasn't there doing sound checks, I was with him when he was doing the sound checks. If it was too noisy, they turned it down. The comments about the church, yes, did ask for it to be turned down, and instantly it was turned down and turned off until after the service. So I really think this license does need to go ahead, because without what happens down there, it won't just be those concerts or the show and the bonfire that will suffer. Everything else in the village will suffer because of the support that is given to all the organisations of the parish that are put on mainly at the farm based on this licence. And that's basically a lot of what I've got to say. If you've got any questions, I don't want to repeat what everyone else has said.
Thank you, Mr. Morris. Councillor Brown.
Mr. Morris, it sounds like you're very involved in all the activities. How do you account for the evidence of damage, etc., resulting or consequently after events?
As quite a few people would say, I do spend quite a lot of time in the local pub, and the local pub has a lot of conversations going on. I've never heard of any damage as such going on. You know, after any of the events, we're up and down the village, we collect the cones in, we put them out, we tidy up, we do everything we need to do, and at no point is it any sign of anything major damage. We work very closely with the police. They're always happy at any of the big events, especially the show and the bonfire. They're in full support of what we do.
And the committee that you're involved in, have they received any complaints of damage or any related incidents?
As far as I'm concerned, none of the show, the bonfire, or the certainly not the bike ride. We don't have any complaints of damage. We do have complaints of traffic and things like that on the bonfire, but the people that know what goes on in the village, we'll have over 120 helpers from all local organisations. So we've got over 10% of the village that lives there helping out on these events.
Thank you, Mr. Morris.
Councillor Panther.
Yeah, two points, please, Chair. Firstly, on furthering to what Councillor Brown has said, what do you say to the comment from that lady who said her husband's car got an axe head imprint on it? That is surely evidence of damage.
I'll be honest with you, I haven't seen that evidence of damage at all. So I don't know if anyone else has, but I certainly haven't.
Secondly, obviously you're stressing a lot on child and public safety, which is good. Do you know, as regards to the security and stewards there, are they licensed professional stewards or just local people?
At the bonfire, it's all local helpers and support. There is a lot of them there that, because of all the different organisations like the football club, cricket club and things like that, they are also DBS checked.
But not licensed security?
Not all of them, and not licensed security. Like I say, we do have the police in attendance to everything that we do, so we have their full support behind us whenever we're doing. So if there is any issues, they sort it out for us.
Mr. Morris, you said you have the police in attendance. Is that just on Betley Court Farm site? They're not in attendance in the streets or anything like that?
No. The police are in attendance. They're on site. They're off site. We did have motorbikes in attendance for a few years, but unfortunately they were busy at Stoke City Football Club on quite a few of the occasions. So we have the bonfire, so they're not available. But the police are up and down the village mainly all day, and certainly till probably 10:30, 11 o'clock at night, which is way after we've finished. I'd also like to comment on the show. One of the sound problems earlier on, the shooting was finished before 6 o'clock at night. There wasn't anyone on the showground at 8 o'clock. It was done, closed up. So that's false comment.
I'm just looking at which somebody's put on the Facebook page regarding that they couldn't get out, so they drove through a hedge and got back in 10 minutes. What a result. Can't beat a good old off-roader.
That will be the common lane issue again. We have taken as precautions because in the past they have opened gates to get out against our will. We have in the past last year, which is why they've ended up driving through a hedge. We actually dug a trench in front of the gate and put a tree trunk there to try and stop them with the good old four-wheel drives getting out. But unfortunately, someone's gone through the hedge. We clear that ground. It takes us about 4 hours to get everyone on for the bonfire. An hour and 20 minutes we're clear. You don't get off that quick from Stoke City Football Ground, and they've got A500 next to them. So I think as far as getting people off, we have signage up to get people to stay longer, because if you stay around the fire and the fun fair, that extra 15, 20 minutes, there's no queue. But like I say, we're an hour and 20 minutes and we're clear, everyone's off.
Okay, thank you. Mr. Cry, do we have any questions?
Questions? Thank you, sir.
Anybody else? No questions? No. Okay, Mr. Morris, thank you for your time.
Thank you.
Okay, Matt, I do believe there's one more. Is that correct? Would you like to invite them down, please?
Yes, thank you, Chair. Suzanne Horrell. They've gone. In that case, Chair, no further speakers, and it will be the applicant to put their case.
Sorry, we did have Dennis Morris, who's a witness for Jane Speed. If he can speak, please. I don't know if he gave his name to you earlier.
Sorry, what was his name, Mr.
Dennis Morris. He is able to speak as a witness, if that's.
I think that would come under as a witness for yourselves. I think it'd be for you to put your application across and then
yes,
witness
okay.
after.
So I suppose yes, in that case I'll do it later, sir, if I may.
Okay. I suppose so we've all done, then it is down to the applicant now.
Yes, Chair.
Thank you. So I'll address the committee, and then you may well hear from both Mrs. Speed and from Reuben Speed, her son. So you've heard a lot of details, and you've heard comments both against and for, but I think what is always important in an application of this nature is to focus, of course, on where the application is now, not perhaps either where it started off or even where it isn't. And I mean by that the reference to concerts some years ago now, which fall under a different license and aren't relevant in terms of their effect and the huge numbers involved on what we're actually talking about with this particular application. So what we have is a modified application, which in my submission, I know Mr. Rankin will disagree, but that represents a reasonable and balanced license, which if granted will replace the existing license. So not to forget that there is an existing license allowing for the 5 events plus the shows. What we have here is a situation where the police and environmental health have agreed to this application on the basis of what are comprehensive conditions in my submission, more comprehensive than the existing license that operates for the 5 events. And those conditions do address, together with the aspects of the application, they address the licensing objectives, potential crime and disorder, public safety, child protection, noise nuisance. Can I propose that really the only issue of primary concern, I mean, obviously crime and disorder is always there, but bearing in mind this isn't the concerts and it's a different nature of an application, and it's private events or theatre shows. or the Betley Tea Room. We are really only concerned with noise nuisance issues here in my submission as a primary factor. And on reading the representations, I would hope that the committee will agree that there is and hearing today persons who've spoken, the committee would agree that there is a lot of positive feeling towards the Speed family, praise for the way in which they have run the custodianship of the farm and events associated with the farm. And there is a genuine trust, which is an extremely valuable commodity in the licensing world. A genuine trust as to how they will run future events if the license is granted. And just as an aside there, it's very easy to be critical of events held in 2014 on a first license where things didn't quite go right. But we've also heard that things did go well as well in terms of the concerts held. And that's why I would ask the committee not to pay undue attention to the concert experience, as opposed to really what has been happening with private events, with the Betley Bonfire, the Betley Show, which has demonstrated in very clear terms that the Speed family know how to run large number of events, far larger than what we're asking for as the additional elements of this application. And that can give a considerable amount of confidence to the committee, and indeed to persons present and absent as to how events will be run in the future. So there are a number of long-standing residents of this village who know the Speeds well and don't have a word to say against them. Nigel Brown, an immediate neighbour, he's not here today, but in his representation, he says, as an immediate neighbour, he says, over many years of events at the farm, we have never had reason to complain about activities on the farm, and the Speed family have always tried to ensure that their activities do not impact their neighbours. I would ask the committee to agree that that will not change. You've not heard from them yet, but you've got a flavour for what their nature is and their character is. And so irrespective of the permission that's granted today by the committee, if indeed you do grant it, they will be very cognizant and aware of any issues that arise in respect of those events. But perhaps more to it than that, because they have held a number of private events, so that whether it's charitable, good causes, whether it's community events, weddings, anniversaries, they have held a number, some of them under the temporary events regime, some of them being applied for by the bars company, and some of them have been part of the 5 events that they're permitted under the current license. They wouldn't be here today if it was a good working way forward to just simply rely on the temporary event process. It does have its awkward elements to it, but more than that, it does have its limitations in terms of the capacity, and that's why the application is for a higher capacity than the 499 would permit. And that doesn't mean that some of the 10 events that they are asking for, the 10 special events, wouldn't fall within the 499 capacity, therefore a 10 capacity, and they've said that they would hold those on the top field if you approve this license. So if there aren't any problems really, as seems to be the message coming through with the private events that have been held so far, and we've got comprehensive noise conditions, most of which, as I've confirmed, will attach to the license for these events, even at the 499 or less, then what seriously is the problem with just extending that permission for a slightly higher capacity and allowing for a later hour? You know, if the conditions are there to prevent noise nuisance, the conditions are there to prevent noise nuisance no matter what the capacity or the time, in simple words. It would be different perhaps if we're talking about concerts. We're not. And it's already been confirmed here that we have modified the application to limit this to, at the moment, a 1,500 capacity. And I'll come back to you later on that. It is also notable that I've mentioned one resident, you've heard from others today, but it shouldn't be forgotten when you hear of the retired doctor about the feeling in the community. Well, the feeling in the community would have been demonstrated in my submission by those who took the trouble to attend the parish council meeting on the 15th of July. I don't want to be petulant about this. Some may not have been able to attend and would have wanted to raise an objection. But 30 of the 31 who attended that meeting actually supported the application. And there was one other person who wished to reserve his views. And it's important to note that this support was on the basis of the application that was submitted, the original application that stirred up a little bit of a hornet's nest with the flyer that was sent round. And I make no criticism of that. I know these things happen in the licensing world, but certainly people were clearly aware of the application having been made. So the support that was at the parish council meeting, the support that those who made representations in support have done, was before we've actually modified and clarified the limitations on the application in terms of the 1500 maximum capacity and the use of the lower field, which whatever way you look at noise nuisance, if you're in a lower position, it generally will have the advantage of noise attenuation, unless there is very adverse weather conditions. It's always subject to weather conditions, which might give rise to a high wind, taking some of the sound out of the hollow area. But obviously, you know, logic dictates that in the general position where you have directional speakers located appropriately with appropriate sound level controls as well, which will be part of the noise conditions agreed with environmental health, then the lower position does have that advantage where it can be used. And that's why the higher capacity events would take place there if agreed by the committee. So the comprehensive list of conditions agreed with environmental health and the police help and satisfy the management and promotion of the licensing objectives in my submission. This reassurance to most, if not all, of those who've raised objections or some reservations or comments about the application, again, all before the modifications have been made, will give, I would hope, a degree of good comfort to the committee in considering this application and approving it. A number of those who've made objections really raise concerns. It's not universal. I'm not going to pick every single representation, but if you read them carefully, the objectors, they really raise concerns about bonfire, the traffic in particular, and the fear about disturbance from events throughout the year for a 4,999 capacity, which is where the application started, and is considerably moved from there. But it would be churlish to say, right, I've got real problems with the traffic at the bonfire, and then at the same time say, well, I don't have any problems with the bonfire. It's got an incredible history in the village, or indeed the show. Nobody's really said anything about the show, even though this weekend, last weekend, apparently 5,000 people attended. And so, you know, an example of those, I'm not being selective here, Michael Reeves, concern about the bonfire, traffic management, Mike Prickett, Liz Middleton, Jacqueline Hemmings. Again, it's these either the concerts or bonfire traffic, perhaps show traffic that
Mr. Cry, apologies for the interruption, but I'm sure myself, there are quite a number of people that are got some level of confusement because the application was changed on Friday, and I certainly have not got this new application in my agenda because it was printed midweek. So for all, please, could you explain what this new application is about?
Right. So I do apologise, sir, and I've realised now that perhaps I should have checked with you at the beginning that you had the additional agenda paper. Agenda
Apologies,
papers.
it has been sent round to all parties, so you should have had a copy of that on Friday.
So if it helps, I do have copies. I brought along quite a few copies, as I said I would, just in case it didn't get through. Can I pass this up to you, sir? And I know Mr. Rankin has got a copy, but I do have quite a few copies if others wish to see it. Thank you, sir. Yes, sorry. Yeah. Pause whilst you read that, and then I'll come in to explain.
Yes, please.
Yeah.
Right.
Can I explain in my defense that that I didn't actually get involved in this application until a week ago, last Friday. So I didn't submit the application itself. I know that the Speed family had assistance from the licensing authority in relation to that application, but it was only following the receipt of all the objection or the representations against the application that I became involved. And then I had a telephone call with Mr. Walters, Darren Walters, on the Monday, and then a further communication on the Wednesday. And he wasn't, for other reasons, he was very busy. He wasn't able to get back to me until the Friday, which is why it's quite late that this has come through with the change in the modification of the application. So essentially, and I'll turn to it now because I was going to, what we have is not an application for 4,999 people, 365 days of the year. If we can break it down, first of all, there's the tea room, which I think, apart from this issue about whether outside area is restricted to 9 p.m., it's only a small-ish outside area, small outside area anyway. But the tea room, I don't think anyone has any real objections to, other than perhaps that issue. And that would allow for the those who are in the holiday cottages to be able to have alcohol brought to their cottage so they can take them there. If any alcohol is taken away from the tea room, it will be in sealed containers only. The police, by the way, didn't ask for that. We volunteered it. Turning to the Betley bonfire, the Betley show, well, those are permitted under the existing license anyway. And I don't think, again, anyone has any real objections, although they've complained about issues relating particularly to the bonfire. And it's the same hour, finish at 22:30. There's no alcohol at the Betley bonfire. That was volunteered as a condition in the application, agreed to by the police. And of course, that won't change. No sale of alcohol and no alcohol brought to the Betley bonfire, which is part of the police conditions. To the extent that regulated entertainment may be relevant to the bonfire, well, I've included that because it may be that there's some entertainment which doesn't classify, at least there's an argument about whether it classifies as being incidental, which would be exempt. But I don't think that's going to be an issue based on the history of that event. The Betley show, as I say, same hours, same applies, and I don't think there's any objection to that from anyone that I could hear. Now, included in the existing licenses, and I haven't made a note of this on this summary document, included in the existing license is the Betley, if I get this right, Gun Dog and Game Fair show. That hasn't been held for a few years. I mean, taking pandemic years aside, that hasn't been held for a few years. And my clients are happy to exclude that as an additional event from those held under this new license if granted. So in other words, that's something that is, well, frankly, conceded because my clients don't need it. So there won't be a Betley Gun, Dog and Game Fair show. The third element, sorry, is the plays or theatre shows and the films. So this is a new element of this application, and this will be restricted to a 22:30 finish. It would be captured by the noise conditions, the noise level conditions, and those following. So is it from 4 to 9, I think, in the noise conditions? Yep, conditions 4 to 9. So it would be caught by that in terms of sound levels. Capacity 1,500 for any event taking place in the lower field, which obviously has a lesser noise impact, but still subject to the noise level conditions we've talked about. And if there is, you know, a smaller film or theatre show taking place in on either the top field or in the shed, which is adjacent to the farm building, the capacity will be 499. And I think you heard complimentary views on the Annie Get Your Gun and the other show that has been held. They were held under temporary event notices, and Mr. Reuben Speed is particularly keen to develop that cultural element to the application. And let's face it, provided the noise levels are right, which the noise conditions and the speeds approach to this would, I hope, persuade the committee that it certainly should be, then there is no issue really with public disorder, nuisance, crime from those who are attending these kind of shows. Some of the events may be drive-in only, and certainly they would look at perhaps having the car speakers on a Bluetooth approach for any audio, but that's not guaranteed at this stage. And if it is the case that there is audio from the amplification for the films, then it would have to comply with the noise conditions, and obviously at the higher capacity, that's where they would take place in the lower field. Then the special events, if I can turn to those, the first point to make about special events is that they would be in marquees. Perhaps this isn't clear from this summary. This was only a summary, but they would take place in marquees, those special events. I am right in that. Yep. And they will be private events. So again, we're talking about the kind of events that have been held by the Speeds over many years, either under the 5 permitted per year on their current license, or under temporary events. But they've always had this restriction, and it has been a difficulty with some events, not all of them, but some events where they would have wanted to be able to take the numbers to a higher level. And also to an extended time, to 1 o'clock in the morning. That doesn't mean all events will be at a higher level, and it doesn't mean all events will be at 1 o'clock in the morning. But it does allow that flexibility for them to book events, limited to 10 per year, so that they could take place in either the lower field again, if they're larger events, or on the top field, or the shed, if it's a smaller event. So I discussed this with the Speeds, and we identified exactly what it is they would need to make this work. In all truth, having heard what's said and the Speeds are, very considerate of any potential concerns and trying to, give comfort to villagers who it seems perhaps are not entirely at one, shall we say, at the moment, but one hopes that that will change. And they would be able to, they feel, reduce the capacity from 1,500 to 1,000 as a maximum. So there is that further concession that we are offering now in terms of those 10 special events, not to exceed 1,000 people. So again, if these events, many of which are held for private parties, charitable events which have been supported by the bonfire funds, if that's just one way of the Speeds being able to earn a little bit of additional revenue, limited as it is, controlled as it is by the conditions, then I would hope that even those who are objecting vehemently today can see the advantage to all, and many of them may well be utilizing that facility as well if the license is granted to allow for that. Sorry, I do need to come back to the plays and films because there was I'm just pausing there. There was a modification to that, wasn't there, in the films? Just, I'll have to go back to my notes. So I'm sorry. There's something about the films that I know that we wanted to give some comfort over. Oh yes, sorry. It was mentioned. Wasn't it in the evidence that was given by Tricia Gee, and I was asking her questions, and my clients would be content to limit the number of plays and films that fall within that category to 50 per annum as a maximum. It is notable, and Mr. Rankin, of course, used this opportunity to keep referring and hammering home 365 days. So it kind of seemed as if this is a 365-day license. And to the extent that we had modified it to, arguably that's correct, because for theatres and films, it could potentially be 365, not that they would ever have 365, 364, 65 days worth of plays and films, but to allow for a show run and to have the flexibility to be able to provide them seasonally, whether it's Christmas season, probably will be in the shed in a marquee, or in the summer months, if we can ask for a flexible arrangement to when they take place, but limit it to a total of 50 event days for theatre and film shows, then that is the modification, again, to this part of the application, which I hope would meet with the committee's favour. Sorry, I'd slightly moved away from my track then, so because I kind of focused on the modifications, which I thought you were aware of, but sadly you weren't. So the representation from David Dunkley, which is at page 115 in the representation, you don't need to turn to it, sir, but he is supportive generally of the application, although he raises a point about the location of what he calls major events. And he includes a map on the page following, so I think that will be page 116. Perhaps this as well to turn to it, sorry. 116. And he's kind of this is Mr. Dunkley's map, and he's sort of identified where in fact the lower field is, and that would be where my clients would intend to have to hold the higher capacity events, which, as I say, for the special events would be restricted to 1,000 now as a further capacity, so not 1,500. So 1,000 for the special events. And some may take place in the top field for the special events, but certainly that is one location. And the theatre shows, the films, they would all take place in that lower field. But for the theatre shows, we would like the 1,500 capacity to remain. But that just helps to identify where the lower field, or mere meadow, as it's called, is in terms of the plan. So the general principle is that those with a lower capacity, and in the conditions that in the document that we've just been discussing, the lower capacity is 499 or less. They would have a low impact. They're no different than events that are held under a temporary event notice all over the country. And they would be held on the top field in the park or the shed without any detriment to the licensing objectives in my submission for those for those of the 10 special events, should you grant that. And as I've mentioned before, my clients have held a number of events already. I think it's 16 in the last 6 years, and that excludes the 2 pandemic years, without any noise concerns or other issues arising. So returning to the objection representations, 2 were withdrawn before the modifications were notified. Others have been withdrawn, as you've heard, as well. And many of them are complementary of the Speed family and their custodianship of the farm and how they run events generally. The parish council have made a comment about the exit route on Common Lane, and I did say to the councillor who appeared that it's really a matter for the committee, but I wouldn't have thought that it's necessary for that to be a condition on the licence. I'm not sure that it specifically relates to the licensing objectives unless you treat it as a public safety issue. It doesn't matter if it is imposed, because my clients are happy that that is what they will do, to only use it as they tried to, in fact, for the bonfire last year, was it? And so it's not an issue in terms of that position for the common lane only to be used for emergency access or egress. In the representation from Tricia Gee, she refers to the, I think it was written, yes, I'll just refer to it. It refers to the important element of promoting the licensing objectives in the interests of the wider community. And that, of course, is quite right. And this is in your policy. But the policy, your policy, it's actually under the heading contribution to local economy. And so this is where the balance is important, because as well as talking about the relevance to the wider community, of course, it's important to see the wider community in terms of the benefits that licensable activities can bring. And in that same paragraph, you say the licensing authority recognises that the entertainment industry is a major contributor to the local economy. There are currently some 430 premises licensed under the Act, and these premises provide valuable employment opportunities, as well as supporting other sectors of the economy, such as shops, cultural activities, and tourist attractions. And that would apply to my client's application. The next paragraph is on promotion of cultural activities. In relation to the promotion of cultural activities, the licensing authority recognises the need to encourage and promote live music, dancing and theatre, circus and street arts for the wider cultural benefit of the local community generally. And this is what we would bring to the area. A wider cultural benefit from the showing theatre shows in an open setting such as this, or even if they're restricted for weather reasons or numbers reasons to a marquee in the shed. It brings a cultural enjoyment for the benefit of the whole community, children in particular. would benefit from this. Its wider ramifications are great, and that's why so much emphasis is often put on the benefits of the cultural arts in terms of the overall wider benefits that it achieves. So Betley Court Farm is a working farm, but the farming is managed. It's not intensive farming. It can't be for the situation with the show, for example. No animals are allowed on the land for 6 weeks before the show. And Mr. Frank Speed, who's a custodian of the farm, ensures that that is complied with and that all other farm and rural aspects are complied with as well. So diversity of use is important for the vitality of the farmland. And this has the clear advantage, of course, of benefiting the village, as some of the representatives in support have said. Benefits the village, the local community. There are associated economic benefits referred to by Debbie Smallridge in her evidence. Jill Mellor makes the same point in her support of representation. And the not insignificant, as I've said, wider cultural benefits to young and old alike of engaging in live arts performances in a rural setting, or even taking part in their brother's, their sister's wedding, their anniversary, or whatever. So Mr. Rankin raised an issue about the procedure, and I'll turn to that now to conclude my address, and then I'll ask Mr. Reuben Speed and Mrs. Jane Speed to say a few words. The plans have been submitted with this application. As I say, I didn't get involved in it at that stage, but they have been accepted by your officers, and so it is a valid application before this committee. The plans regulations, I think everyone who works in outdoor events and festival licensing, as I have for the last 30 years, knows that the plans regulations are not designed for outdoor events. Nobody really thought about it when they were constructing the plans regulations, which talk about buildings primarily when you look at it. But in any event, what we should, of course, identify is whether there's been substantial compliance and whether anybody has been prejudiced by any omissions, if there are any. And I'm not clear that there are, unless one is very picky about the plans regulations, which is not relevant to the substantial compliance point. And that's the case authority of Jathan, sorry. And indeed, when you actually look at the plans regulations, I know Mr. Rankin pointed to there being no plan that showed the fixed structures, regulation 23(3)(e). Well, when you're talking about temporary structures, they don't need to be shown unless they have an effect upon the fire exit route. So it's inaccurate to say that we've not complied with E, because it's not relevant. And the same would apply elsewhere. Mr. Rankin is using it as a distraction. He knows that, because what he said is, oh, of course, we don't want the application to be thrown out on these procedural grounds. We want it to be, because it will just come back again with another application. But, you know, it kind of demonstrates that the application wasn't put together properly. It was. That's very unfair. My clients took advice from licensing. They went to see the licensing department, took advice on the application, the plans that are submitted. And the plan is really no different, except that it's a kind of Google Maps style plan, the main plan of the area, rather than the sketch plan that's on the previous license. So it's very much the same, other than that slight differential. So I don't think the plans issue is a fair criticism to raise, but as I say, it was probably done as a distraction technique. The other point that's raised is about a comprehensive risk assessment being included as part of the operating schedule, and the criticism that it wasn't. I disagree. The application is comprehensive. It's very thorough in terms of what is put forward in the application itself. It includes reference to the fact that there'll be no alcohol at the bonfire. It refers to a number of matters, far more comprehensive than many I've seen. But it's more important than that, because the significant amount of information that is included in the application actually is augmented by the conditions that have then subsequently been agreed with the police and environmental health department. So they form a package of conditions which create the basis upon which you can then move forward to properly consider whether this application should be granted on its merits, obviously with the modifications that you've seen today and we've been discussing. And in any event, the Bristol City Council and Summerfield case makes it clear that it's really for the applicant to construct their operating schedule as they wish. And it's then for the committee, it passes over once the representations are made, for the committee to determine whether the operating schedule conditions are right, whether they should be added to. And of course, as I've already said, we have the police and environmental health conditions that we have that significantly augment the application that was initially made. So that is my submission. When it comes to closing, I hope to be brief. Can I now turn to Mrs. Jane Speed first, if you would like to say a few words?
Thank you. Yes, Mr. Chairman, just like to say one or two words. Thank you.
You can just speak up.
Sorry, I moved the microphone before. Sorry. Just to say that Frank's lived at Betley Court Farm since the early 70s. His father was a farm bailiff for the squire, and when the squire died, he took the farm over within his own right, as a tenant. And then he continued a tenancy till 1990. When he was 65, and then we took it over then afterwards, Frank and I did, because we got married in 89. So I'm a fairly newcomer to Betley, I suppose, because I've only been there since 1989. I've been Betley Show secretary since 1991. The show, and so this year was 164 years old. So we're hoping to have a show ball next year when it's 100. We have one every 5 years when it's 165 years old. We're proud to live at Betley Court Farm. We love everything that goes on in the village. We take part in everything. We just think it's, to live at Betley, it's just amazing. And we wouldn't like to live anywhere else. Ruben, our son here, has been to London to do to university to do a theatre design, and he wants to carry on doing some of these shows at home on the farm. So I'll hand you over to him. Thank you.
Afternoon, councillors. Thank you very much just for spending a day here as well. So just regarding the license on the application, really part of it was to, support my endeavours as it has been quoted, I'm a London thespian. I will just remark, I'm not a London thespian. I am a theatre designer that went off to London, but obviously through the pandemic, returned home. And I do still commute going up and down with jobs down there. But obviously the big thing for me was to try and offer something within our community as live entertainment again. So in 2020, we did the Songs Under the Stars musical concert. This was one of the first live events back in the borough. We worked extensively with Darren, with Lisa, all the authorities to get something back up and running. And that was my first entry into doing events, I guess. So that was the first one. It was a success. We managed to do something in the COVID year. We had no sort of guidance really. It was very vague. We managed to put something on, and it was a success. A lot of the objectors here today, or who wrote in, came to see it. We did that on a temporary events. However, I had a waiting list that meant I could have gone over on the numbers. We were inundated with people wanting to come out and bring back that community spirit, which is a real big part of us and of Betley. I'm very proud of Betley to be there. Then last year, I then went on to try and, I did produce Annie, Get Your Gun. This is one of the first musicals that we've done. We performed it in the round outside the day after the restrictions finally lifted. So this was back in 20th of July, 2021. So this is the first time, again, the borough had seen anything back in the area. And I'm very proud of that. We utilised local students and performers in there. We had a professional cast who have been all out of work, and we used local suppliers to do this event. And that's a real big interest for me, is to make sure that we keep doing these kind of live theatre performances and events so that it offers work and economy to the surrounding area. I'm, like I say, I am proud to be part of Betley. We also got national recognition in that. We were in the Daily Mail, we were on BBC Radio 2. I don't think many other villages in the country can say that they managed to do that in a pandemic year. We've always worked so extremely hard with everyone to make sure that things are run successfully and correct. This would not change. We still would want to collaborate with all the authorities to make sure that we are doing things correctly. I find it quite interesting and exciting when you have a problem, you have to sort of creatively solve them. And we're always working with everyone to do that. I haven't actually got a speech. I'm just sort of, rambling now, but it is a real, we offered that community spirit, it was the well-being. We were bringing back events, and this is what I would like to try and move forward with that. Obviously, it's a little bit more, I guess, flexible in some of the wording because, as you know, temporary events, it only restricts you just to that week. With everything that was going with weather and stuff, you have to be able to maybe amend those. So if it is forecast and you have to cancel, you can then move it on to a next week or so, whenever it works. So that's really where the whole thing is. People keep saying we're going to try and bring back the concerts. We will not be bringing back the concert. It's not a viable option with this license. It just isn't. Everyone's comments have all been because of the concert. We won't be having that. That concert license was for 15,000. We're going now down to 1,500. So we're really getting at 10%. We're losing a vast amount, just having that for the outdoor events. So yeah, I'm trying to think if there's anything else, but no, I don't think there is.
And can I just ask, both of you to confirm that the changes to the application that are before the committee on the piece of paper and further modified today in evidence would apply? And by further modified, I mean, Ruben, in your case, 50 maximum event days for the theatre productions and shows. And in relation to the 10 special events, that they will be restricted to a 1,000 capacity rather than the 1,500, which is in the document. Is that agreeable?
Yes, it is.
Thank you.
Okay, thank you. Before I go any further, Matt, did you want to come in earlier on?
No, not really, Chair. I think we've gone through the procedure sort of at length to explain what all parties have felt. There've been a few points raised from different parties, which we could come back on if required, in terms of past applications and in terms of certain conditions and things. But unless there's any specific questions at the moment, I don't think we've got anything.
I just wanted to check with you whether you wanted a copy of the environmental health conditions, because that was on the same email that was sent to you. You've got that. No, it's in addition that was sent on Friday. Yeah, okay, I'll sort that out for you.
Mr. Cryer, would you be happy to have a condition that all events will be in the marquees only?
Certainly that would apply to the 10 special events if approved, and that is agreed. So I didn't mention it then, and I should have done, because that's one of the further clarifications, modifications. So that is agreed. It wouldn't be possible for some of the theatre shows, of course, because the idea of that is certainly for the larger ones, if approved, that they would need an amphitheatre type setting, you know, seating outside. But the smaller events, so if it was an event in the shed, can I just ask as part of the answer, would that be acceptable for it to be in a marquee in the shed? Yes. Okay. So if it was an event in the shed, then it would be in a marquee for the theatre shows, films, or the special events.
Councillor Brown, do you have anything to ask?
Two things. I'm glad to hear the marquee raised, because it was raised in the evidence as a limiting factor on the sound. So glad to hear about that. But you're talking about 48 hours notice in advance. Now, I'm not experienced how long it takes to put up a marquee. Is that going to be an issue?
Invariably, there would be far more notice given. You know, if someone's arranging a wedding reception, then you would know about it a lot further in advance. The idea of the 48 hours, you often see it in conditions for pubs, is to demonstrate that it's private, that it's not a walk-in off the street. And therefore, that kind of restriction on somebody just turning up applies. You know, so the event would be already organized, and you would know who they are. And I think it's included as well in, it should be if it's not. Yes, that the events would either be private, so therefore restricted by nature of those who are inviting them, as in wedding or an anniversary, or they would be ticketed. Now, clearly, if they're going to be ticketed, it would be more than 48 hours. If that issue particularly concerns the committee, then 7 days, 14 days, I don't think will be a problem for the organisation of those 10 special events, because we'd almost certainly have more notice. The one potential difficulty is if an event has to be moved at short notice. So the marquee is already up, but you know, for whatever reason, somebody gets COVID, I'm going to say, then it's moved to, you know, a couple of days later. And that's just where you need the flexibility in terms of, it wouldn't probably be a couple of days later, but say the week later. That's certainly where you need a degree of flexibility in the wording of conditions.
Thank you for that. Secondly, maybe this is a question more for the speeds. What's the difference, either commercially or in any other way, in serving alcohol till 1 o'clock rather than stopping at 11?
Thank you. So, Mr. Chairman, if we have a charity ball, like we had the big yellow ball a few years ago, 10 years ago, because the vet in the village, his little girl was born with a liver condition. So we had a ball for the Children's Liver Disease Foundation. And if you have a sit down, we actually sold 460 tickets to that, Joe. So we could have sold a few more. We did have a waiting list for numbers, but we couldn't obviously go over them because we did it on a temp event notice. So if you have a charity ball like that and you're having a meal and you sit down, you know, and then you've got your speeches, then you've got a raffle, then you've got an auction. Sometimes you're still sitting down at the table till 11:30. So it was for those sort of events, to go till 1 o'clock, really. That was all.
Thanks for explaining that. And just one more question through the chair. The films that you're thinking of showing, are they family films in general?
They would be. So, a lot of the things we try and do is make sure that things are family orientated. Nothing that we've done in the past really has ever really qualified for it not to be. Even the concerts back in the day, if someone says Happy Mondays, when there's evidence to show that people did bring their kids to that concert and they were safe and they enjoyed it. So everything we have done and will continue to do is really at the forefront of the community and young people. We want them to experience outdoors and live events. So that's really where the the onus is on this new license, especially on this edition, I will say.
So you're not planning on gory or violent films? We're glad to hear it. Thank you.
I do apologise, but can I come back to you, Mrs. I do apologise, Mrs. Speed. What did you say about you wanting to go to 1 o'clock? Can you just repeat that for me?
I can. If you have a charity ball, it often involves an auction. So you might all sit down at 7:30, 8 o'clock, for your food, and you might have, your starter, your main, your desserts, your cheese board, and your coffee, and then you've had a raffle, and then you have your auction, which could take another hour. The auction, I don't know, depending on how many lots you have. Sometimes you still sat down at that table at 11:30 at night. So I thought if you're having like a dance afterwards, you need to go till 1 o'clock. That was all. It wouldn't be on all of the events, just on some of them like that. I mean, a wedding could finish at midnight, couldn't it? A wedding. But I think a charity ball, when you're obviously trying to raise money for charity and you've got the auction and things, it goes on a bit longer.
So you're purely asking for the 1 o'clock license, but based on a charity ball event only? Yeah, on a charity event. Yes. Yeah. Okay, thank you.
See, when we had the big yellow ball that night, it raised £35,000 for the Children's Liver Disease Foundation. At 1 o'clock. Yes, sorry, and it went to 1 o'clock.
Thank you. Councillor Panter, do you have anything?
I did have one question, but my colleague's beating me to it, so nothing further. Thank you.
Does anybody else wish to ask any questions of the applicants? Mr. Rankin, please.
So nobody in particular, but probably to you, Reuben. You said this, that you have no intention of ever repeating the concert. Would you be prepared then to surrender your concert license?
We wouldn't be prepared to take away the concert weekend license, which is the second weekend in August. That was in condition to this new license, that we were never going to bring back a concert, on any of these conditions.
So whilst telling the committee that you never intended to repeat what happened in 2014, 15 and 16.
Yes, the thing with that concert license was, as you will be aware, it was for 15,000 people, well, for 14,999. Obviously, the license now has gone down to 4,999. Yes, it's gone down to for the concert license. That's on the 2nd of August, the second weekend in August. So it's not as if there would ever be another concert like they have seen like we will never do a concert like it has been in the past.
Just so that we can be clear, because there was a review of that license and because the numbers were then restricted to 4,999. All right. You still have a license. That license enables you to hold a 3-day event over the second week in August, up to 14,999 people.
No, sorry, no, it doesn't. It's for 4,999 people. We amended it.
Yes, I think, can I help here?
A few years ago.
Because I'm talking from legal knowledge as I understand it. I believe that the license was in effect turned into a 4,009, the licensing clerk will be able to assist here, but turned into a 4,999 license by virtue of the payment of the annual fee only being relevant to, oh no, I'm getting a shake of the head. So I'll leave it to your
Thank you, Chair, if I may. No, the Speed submitted a minor variation application in relation to the premises license with a view to removing the capacity, which at that time was 14,999, down to what would be, what we say, a normal license where the maximum would be 499 and would not incur a further additional annual fee. So it was that process that.
So you still have that license. You don't want to surrender that license. Is that right?
No.
And the reason that you don't want to surrender that license is because?
I think in the context of this is that we don't, there might be something where we say, right, let's do, a smaller concert again in the future. But that's not, so we're not ruling, we can't say we'll never do anything, because that'll be silly of me to say that. I don't want to make promises to anyone. But at the same time, the trust and honesty that we have had throughout the whole past events, we have spoken to people, we have put things on for the community so that they are involved. We're doing things to offer that sort of well-being and positive aspects to it.
Furtherance then of that trust and honesty, when you said that you had no intention of doing a concert again, a large-scale concert, you meant of the type that you did in 2014, 15 and 16. But you still have a license that enables you to put on a concert for 4,999 people. You don't want to surrender it because you think that at some stage in the future you might want to use it. Is that a fair summary?
To some extent, that might happen, perhaps, yes.
Up until Mr. Cryer amended your application on Friday, do you agree with me that the application that you put before this licensing subcommittee enabled you to hold events 365 days a year?
Sorry.
Can I just
Up until
remind...
the moment that Mr. Cryer amended your application on Friday, do you agree with me that the application that you initially submitted before the licensing subcommittee enabled you to hold licensable activities for 365 days in the year?
The initial idea of the license for 365 days a year was for the tea room, because we have had some evening events in there, and we have done funerals when we've been closed on a Monday or Tuesday. So we don't have to then close. If we do them in the rest of the week, we have to then shut to our regular customers. So that was why it was 365 days until 10:30.
I would like to just add to that, if that's okay, Mr. Chairman, that, we would never go to do a 365-day event. I mean, not even those in large scale like Wembley offer a 365-day event. It is not. It's not. You can't possibly do it. There's all the money involved, all the everything. You just wouldn't be. It wouldn't be feasible or possible to do that.
So you're going to restrict yourself to these 10 events in response to questions from the chair and Councillor Brown. You've indicated that you would be prepared to have all of those 10 events inside a marquee or in the shed, in a marquee. And in response to the question of the terminal hour, you've indicated that people are still sitting down at a charity ball until about 11:30. Did you have any resistance to a terminal hour being put on the charity ball or these 10 events to 12 o'clock?
Yes, for some of them. I think some events could finish at 12 o'clock, like a wedding, but I think a charity ball, especially when you've got an auction, no, I think it needs to go to 1 o'clock, sorry.
And the attendance at the last charity ball that you did was what?
460.
And was there any difficulty in you obtaining a temporary events notice for that?
No. But we did have a waiting list for ticket sales. We could have gone over that. We didn't go over it, obviously, because it was a temporary event And you have to obviously include all your staff and, you know, your bar staff and caterers and things.
Whilst we're on temporary events, it seems that you might have misunderstood the legislation. Was it your understanding that the capacity of 499 on a temporary events notice applied to everybody? That was all attendees and staff as well.
Yes.
That's what you thought.
I did.
A temporary events notice authorises attendance by members of the public. Members of staff are excluded. So that's 499, excluding staff.
That's not what I've understood. And
Well,
I've been
take it from
applying
me
for them
that-
for a long time.
That's what the position is.
Can anybody hear me?
Yeah, I've just coming in. Okay, if Anne-Marie, if you'd like to make a comment.
Yes, thank you. Can you hear me?
Yeah, you got you.
Can you hear me?
We can.
Hello. Okay, good. I was just want to remind the participants that this is not a venue for cross-examination. You can ask questions by all means, but it's supposed to be led as a discussion rather than cross-examination. So if you can restrict you to just questions and not trying to put the applicants under the spotlight and trip them up, please.
It's ingrained into me. Hard work.
The lawyer, Mr. Rankin, may I say. Too much
40 years at the bar. Having been admonished, can I just finally ask this question? Have you ever encountered any difficulty in applying for a temporary events notice?
No, I haven't. But I did always think that 499 included every single person on site,
All right. Thank you very much.
whether I'm right or wrong.
Mr. Rankin, does anybody else wish to make any comments or have any questions to the applicants? I'm taking that as a no. Okay then, so unless the officers they want to add anything to this. No.
No, thank you, Chair. In line with the procedure, the next stage would be for the applicant to sum up their case. Thank you.
Hey, Mr. Cry, would you like to sum up?
Procedure also has the representatives are also able to close. Oh, yes, I do apologise. Yes, you're correct. So it would be for the representatives to close their matters at point 14 of the procedure, and then 15 would be for the applicant to close.
Sum up.
So
Don't know if I think
yeah,
what
I
you-
agree. I'm sorry.
Yeah.
Yes, I apologise. It's actually for the other interested parties to close first and the applicant to go last. So it will be for people who have spoken previously if they wish to close.
Okay, do any members of the public gallery wish to close in on the application's comments? I think, Mr. Rankin, you're the only person that would want to sum up. Yeah, nobody else has raised their hand or indicated to me otherwise.
The witnesses who've spoken to you say this. Well, nobody's complained. We don't have any problems. We haven't had any problems over the last 5 years. And we say the answer as to why they've had no problems is an easy one. It's because your committee granted a license in 2015, which gave certainty. The license gave the residents total certainty. They knew exactly how the farm was going to be run and events at the farm. There were going to be 3 of the Betley show, the Betley bonfire, and the game fair, which is now no longer in play. And then there were going to be these 5 additional events, and they were going to be until midnight. That gave us certainty. We understood precisely where we were with that. And then in addition to that, they were going to apply for temporary events notices. And that's worked extremely well for the last 5 years, save for the incident with the farmer's ball. But that's an interesting one because a capacity of 650, we know, caused a problem. Capacity of 450 doesn't. And Mr. Cryer is saying, well, it really doesn't matter. It's the question of the equipment that's being used. Certainly, 450 people cause less impact than 650 people, and certainly less impact than 1,500 people. And what has happened over the course of those years has been a quiet, peaceful coexistence. The application that's been put in now, up until the moment that Mr. Cryer amended it last Friday, certainly set the cat amongst the pigeons. I don't want you to think that a meeting of the parish council and non-attendance by objectors to the application is an indication of anything. Parish councils, as you know, work at grass level politics where it's perfectly possible for personalities to take over at grassroots level. And it was a sensation that was felt by Mrs. G that there was little point in turning up at the parish council meeting because it was a fait accompli as far as Mr. and Mrs. Speed were concerned. And little would be accomplished there. What would achieve accomplishment would be by coming before you, a fair and impartial tribunal, and telling you what the problems were. And clearly there's a division between those that are for and those that are against. And there is no doubting that the Speeds do good work. There's no doubting that the charity work that they do has benefited many people, and that will continue, whether this license is granted or not, because that's something that they do, and that's something that should be applauded. The sole question for you is, well, we're going to place that aside, and we're going to look at this and see what is the wider community, what's the impact on the wider community. And the impact on the wider community is this. You're being asked to grant something which has a capacity of 3 times the capacity that was granted in 2015. You're being asked to do it for double the number of occasions. And in addition to that, you're being asked to countenance the granting of a license for 50 separate events for Mr. Speed Jr.'s theatrical productions. Now, there's never been a difficulty applying for temporary events notices. We know that because Mrs. Speed has just said that. They can apply for them. It's not going to cause them a difficulty so to do. So what is the solution to this conundrum? In no particular order can I deal with some matters that were raised. I don't seek to criticize Mr. Cryer. He was briefed late in the day. It's possible that had I not asked Mr. Cryer what the position was regarding the theatrical events, it's perfectly possible that through sleight of hand, you would have been asked to grant a license that allowed, although not in practice, but allowed for events 365 days a year. That was perfectly possible until clarified by Mr. Cryer and added to by Mr. Speed Jr. So in no particular order then, we've got Dr. Lane, our witness, who said this. that the Betley show, which took place last weekend, could very well have been taking place in his garden for the noise that the tannoys made, etc., etc. Now, we don't object to the shows. We tolerate the shows because that is part of life in the village. What has never been part of life in the village is the proposed productions that are going to be placed in those two fields. And we had that example of the church bells from Caroline Ball, which is not entirely fair as an analogy. In her analogy, a man comes to the village and the bells are already ringing. In our analogy, Mrs. G is in the village and then somebody builds a church and it's got some loud bells. That's precisely what's happened. She's been here for years and years and years. And what has happened is that what was the village that she knows, and all of the other people that have written representations in, is on the verge of change. Now, you've got some witnesses, Mr. Morris, who says that that will be a change for the good. You've got others who say, I do not believe that. And the reason I don't believe that is because events have taken place at these premises which have impacted upon me. Now, Mr. Morris said that the village will suffer if the license is not granted. No, it won't, because it will continue as it always has. In addition to the concessions that we made when I first opened this case, we make the following concessions: that we agree that a license can be granted for those special events, but that the capacity for those special events should be raised only to 499. So that obviates the necessity of applying for temporary events notices. And we say that they can have those events until midnight. Now, we say that that is a considerable concession. If on the rare occasions Mrs. Speed has the charity ball and feels that she wants to take it on till 1 o'clock, then all she has to do is apply for a temporary events notices. There is no difficulty in so doing. They haven't done it in the past because, well, they haven't really explained why they haven't done it in the past. It's not as if there are any impediments in their way. Insofar as capacity then for these special events, please, not 1,500, 499. Insofar as the events for the plays and such like, we would ask also that they be contained within a marquee for reasons that must be obvious. The containment of events within a marquee is a device that was devised by the licensing subcommittee in 2015 and has worked to great effect, and we would wish for that to continue. We're not accusing the Speeds of being money grubbing, and I'm not entirely sure where that phrase came from, although I think that Mr. Ainsworth used it when he was giving evidence in support of the application. And of course, Mr. Ainsworth is able to say, well, he's never been impacted adversely by the premises because his daughter had a wedding there for 120 people. That's what normally happens. That's the normal sort of function. But I do say this, that placing charitable enterprises aside and the guided walks and the cross-country meetings and the rest of it, placing all that to one side, the reason that Mr. Speed and his wife make this application is not for any other reason. There's no altruistic motive, we would suggest, behind making this application. save for the various obvious one. And that is, of course, he wants to diversify, and of course, he wants to expand his business, and of course, he wants to make money. Of course, we all understand that. But this is where the imbalance is created. And if you grant the license as it is currently formed, then an imbalance is created. Budley, with its 9 events, creates the perfect balance. And we would ask that you follow that. Budley, of course, which is in an area almost immediately nearby, but has far fewer residents. They're surrounded on all sides by residents here at Betley. So let them prove that they can do what they say. Let them, through their temporary events notices, show you what their schedule of events has been, and let them come back to you and say, well, look, it was all marvelous and nobody objected. And we didn't have a single problem with environmental health. But to grant a license which lasts until we are compelled to bring it to review and to make representations against it is, we would suggest, not a fair balance. The fair balance is created by providing a license couched in the terms that we would suggest. That's all I was going to say.
Thank you, Mr. Rankin. Mrs. Glee, do you have anything to add?
Could I, just for clarity, ask you to repeat exactly what you have now arrived at? Because it certainly wasn't clear at the start of the day, and it's been tumbling as we're going. So would you mind awfully just giving us a really clear outline?
Let Mr. Crowley do that, and he's summing up.
Would you? Thank you.
Okay, if nobody else wishes to speak, then I will ask Mr. Crowley if he will sum up on this, please.
Yes, thank you. So it is sad in a way that you have a situation here where you're having to consider an application which has been modified considerably from where it started, and yet there's a criticism for where it started, because the whole approach to licensing is that it should be one where there is consideration for those who've made representations, those who have concerns, those who even, applaud everything that is in the application. And what the Speeds have done is to look carefully at what it is at the nub of the concern of those who have issues about the application, and say, well, no, actually, what do we need? What are we looking for here in terms of the application that's now before the committee? And what they're really seeking is, first of all, the tea room, which I won't press, but I think we're agreed isn't really an issue for the committee today, hopefully. The licensing of that tea room each day of the week. Sorry, shall I pause? So the tea room, I think I won't address further. There hasn't been any pressing of the point about the 9 p.m. closure outside. It's not a big issue, but if some people are outside, a few people, because it happens to be summer, good weather, and they're enjoying a glass of wine, really, why can't they go on to a little bit later a time, even if it's 10 p.m? Doesn't seem unreasonable to me. Particularly if it hasn't really affected anyone, for it being used as an outside area without alcohol so far. I don't think we're looking at drunken teenagers using that, shall we say. The Betley Bonfire, Betley Show, the same as the existing license. The gun and game fair is coming out, should you grant this license. So that is a concession. We could have pretended that this event would come back in a different way. But the Speeds have said, no, that event hasn't been held for a number of years. We're happy to exclude that as part of this overall application. the plays and the films, the theatre productions, Mr. Rankin knows they can't take place in a marquee for them to have the real effect. We're talking about an amphitheatre setting. I'm talking about the larger capacity events, because if it is a small capacity and it's inclement weather, then they might well take place in a marquee, either down on the field or indeed in the shed, as we've indicated. But for the real benefit of the cultural enjoyment of young and old alike that we are talking about, that Mr. Reuben Speed is kind of, really enthused about with his background, why not? Why not bring that to Betley? Why do people have to go to a show in London or some other, large field which isn't particularly conducive to the local enjoyment and participation of young people in an event of that nature? Well, it would only be a problem if realistically there are serious concerns about noise nuisance. I think we can exclude crime and disorder from all this. And what we're saying, quite simply, is that if there is a up to 1,500 capacity theatre production or a film show, that would take place in the lower field. And if there's any suggestion of an impact taking place, that is where the environmental health conditions kick in to control it. So it doesn't need a marquee, it just needs controls, and the conditions apply that control. And the benefits far outweigh the potential that there would be for any issues in relation to the licensing objectives, particularly bearing in mind they're controlled by the conditions. There is no evidence that the speeds, far from it, that the speeds would not comply with the conditions that would be imposed upon them by the license if granted by the committee. They've discussed the issue with Darren Walters. He's familiar with the site. He's actually been to see on previous occasions, or a previous occasion certainly, Mr. and Mrs. Speed to discuss other issues. So he knows about the area. So these aren't bald environmental health officer conditions without any cognizance of the actual area and the locality and what's happened in the past. And he has come up with a set of conditions. In fact, we actually put forward a number of these conditions that he agreed to, but he's put forward conditions. And if I can turn to condition 4 in particular, which would apply to all events, theatre shows, special events, everything. And that is that the level of amplified sound would not exceed 65 decibels over a 15-minute period at the nearest residences. I think that bit has been clarified. And also the second part of it, which I won't recite, but in effect controls both the bass level and also the sound output after 11 p.m., which in fact would be restricted to background noise levels. Now, if you have a condition which obligates theatre shows, special events to not exceed conversational level, the 65 dB, or background levels after 11 p.m., then nobody is affected by it. Nobody can say that this is a nuisance. If they do, it's because there's an exceedance of those conditions somehow not being complied with, and that's where the controls will come in from the other conditions set down here. So the 500 plus events, so the larger capacity events, it's clear from conditions 1 and 2 that they require a different element, a different approach. And that's where the event management plans will be prepared in advance, which would include a noise management plan, 1 month's notice. So this kind of takes the license to the 500 plus. Mr. Rankin says, oh, well, you can rely on temporary event notices. Let's just keep it to 499. Well, you actually get better control from the conditions here, because in my experience, temporary event notices never end up with any conditions being imposed. They're far too much trouble than they're worth. But it's particularly relevant for events that exceed the 499. Now, Mr. Rankin, I think perhaps he misjudged or misunderstood a point that Mrs. Speed was making, that some charitable events, she gave one example, but there are others. or not necessarily a charitable event, a fundraising event, a particular a wedding could actually go on to a later time than has been permitted so far. So you can't say, well, you've already, held events limited to 4:50 and limited to 12 midnight, when in fact you're not able to go that bit further anyway, because the license wouldn't allow it, particularly in the case of the numbers. So I think this really is a very reasonable application in terms of where it's progressed to. And another clarification on what Mr. Rankin said. Mr. Rankin, with respect to him, isn't speaking for the village here. He says we consider that. He's actually representing Mrs. Gee, one person. So he's speaking for her. And he has the right to say we, but let's be clear. These are his views based on his interpretation of what Mrs. Gee's representation is. What he didn't say is that we have stated as part of our submissions that we're prepared to limit the capacity for the 10 special events to 1,000 as a maximum. So if he talked about there being 3 times the permitted number under the current license. The permitted number is 450 for the 5 special events. Well, we're not talking about 3 times, it's slightly more than 2 times if permitted by the committee. Not all of them will go to that number. It's a matter for the committee whether you want to split that and allow some to go to 1,000, for example, others at the lesser capacity. But it does give a degree of certainty and a degree of control, because the noise conditions would then be relevant rather than irrelevant so far as a temporary event is concerned. It would give that degree of control that would assist the committee. We are not a 365-day license, nor are we a 4,999 capacity. We've moved well away from that. We would like the 1,500 capacity for the theatre shows, where they take place in the lower field, controlled by the noise conditions. And we are prepared to limit them to 50 events per annum. That's the amendment so far as the shows are concerned, the plays and films. So, it's sometimes a case with these applications that you almost feel like you need to be in the village to have experienced it, to understand, what causes some people an objection, reason to object, what causes others to fully support it. And I do appreciate the difficulty for the committee, but I hope you can take a lot of encouragement from the supportive representations and submissions that you've heard, and what people have said about the speeds and their approach to events in the village. And this isn't an opportunity for people to say, well, I support the speeds because they allowed my daughter to have a wedding on their field. These are residents which would include, when I say it again, 30 people at the parish council, all in favour. A number of supportive representations, even some of those who are against. Actually, they're not really against. They're against the noise from the concerts. And so I would ask the committee to isolate those issues that related to the concert. And the lady, forgive me, her name is not in my head, but the lady who spoke about the terrible damage that was caused. When I questioned her on that, it was one of the concerts. That was her answer. It was one of the concerts. And of course, it's always going to be a possibility that there's going to be some damage caused from, sadly, it's the world we live in, from a concert like that. But that's a world away from private events organized in advance, people or ticketed events for good causes, for weddings, for encouragement of people's participation in community events, or the theatre shows, and importance for cultural benefit. And so we don't need to look at a Budley as an example. You can pick on examples in other parts of the country where similar farms have actually taken advantage of the licensing process to be able to apply for greater events than would normally be in the past the case for farms. So there is a diversity, and there's nothing wrong in that. The essential question is really the modification to the application, what we're applying for, with the encouragement of the support that you've heard genuinely that the Speeds have. Their trust, they are placing now at the committee's table to ask you to approve the licenses modified, backed up by these conditions in the terms that have been applied. Thank you.
Thank you, Mr. Crowe. Right, we as a committee will now go and sum up and discuss and make our decision before we will return. I think we've got it to go upstairs, if that's right.
Yes, we've set a room aside upstairs for you to deliberate, and there is the facility, if you're not going to come to a decision straight away, to reopen the hearing and tell all parties that a decision will be made at a later time, as long as it's within a specific time frame. But I'll let Anne-Marie guide you on that in the decision. Thank you.
Thank you, Matt. If we can ask IT to pause the recording, and we will go and deliberate now. Thank you. when you're ready to put us all back on.
Can you not hear me? When I speak, it goes funny. Can anyone hear me?
Just waiting for our legal to turn up.
Hi, can everyone hear me?
Mic test. We have the echo. Can we get rid of the echo, please? I think we're good to go. No.
Somebody else got a laptop device.
Can we hear me?
She got two devices.
You what, sorry?
So, yeah.
Can we hear me now?
Yeah, you seem sound now. We're still echoing. And Anne-Marie, can you just put yourself on mute, please? Seems to be. Still the echo.
Yeah.
I'm just going to run with this. Right, and ladies and gentlemen, we as a committee have discussed the issues and that has been put before us. I understand that Mr. Rankin and Mr. Cryer, you've come to an agreement.
That's what I was trying to do.
And apologies if that was misunderstood. So what it is an amendment of our modified application to make it clear what we're applying for.
Yes, Chair. The document that Mr. Cryer has referred to that I've sent to Anne-Marie was just to assist the members in clarifying what all the amendments have been prior to the meeting, but also through the course of the meeting, wherever there's been clarification and concessions. So Mr. Rankin hasn't agreed to what the proposal is, but he had agreed that the document containing a brief summary would be sent to yourselves to ease the decision making and understanding of everything that's happened.
Right, okay. So to sum up then, we as a committee have decided to, well, I will break this down in the 4 criteria that it appears. The tea room, the Betley Bonfire Show, the plays and films will remain as been proposed. But we as a committee would like for the special events that no licensable activities after midnight. Are you happy to agree those terms and conditions? If I can just hand over to Anne-Marie before anybody comes in, she will explain our decisions.
Okay, the decision, can you all hear me? Can you hear me? Perfect. The decision of the committee is to grant the application as modified both prior to and during the hearing, with all the conditions that have been offered to be incorporated into the operating schedule, except for the special events, which will all licensable activities will cease at midnight. Okay.
Mr. Cryer, did you have anything?
I just thought it would be helpful to clarify for all present, exactly what it was, but the modification includes, for example, the special events at 1,000 capacity rather than 1,500, and the 50 events for the plays, the theatre shows, etc.
That was what we received.
That's understood.
Yes.
Thank you.
Yes. And that the environmental health conditions will apply to all licensable activities.
It's for conditions 4 to 9 inclusive.
4 to 9, yes.
Yep. Thank you.
Okay, thank you. Okay, that concludes the business for today. Thank you all for attending and watching remotely. And I wish you a pleasant journey home and a pleasant evening. Thank you.
Thank you.